Good morning, everybody. Happy Tuesday, which at least here in the bunker is just another Monday. Welcome to TCF Live. So here's the thing. Shortly before trying to go live, nothing is working here. At least not the way it should be. I've got two computers that run this show. The one computer isn't talking to the other no matter what I do. It's not sending over the signal. So we're going to try to do this on one computer today. I've dialed down the resolution slightly just to take some of the stress off. We're going to see how this goes. There's a lot of chicken wire and duct tape involved, but we're going to try to put on a show. We'll start our morning with Judge Middleton.
Player here, Danielle Brackett, Booker Jenkins, Jason Kiesler, Pablo Pena, Michael Phelps, Cody Smith, Carrie Walls, and a lot of people that are here. Lonnie Williams is here. Well, maybe some stragglers will come wandering in, but we'll go with who we've got. Let's start with Lonnie Daniel Williams. Mr. Williams, would you come up to the podium, please? This is file number 26251OT, People versus Lonnie D. Williams. Mr. Williams, you got charged under 3 hours ordinance with driving without a valid license. Let's take a look at it. You get lots of these. We have one almost every single arraignment day. You got the ticket on February 13th at 8:30 at night in Sturgis, no, in 3 Rivers, Wood Street and Michigan Avenue. Driving on a valid license, stopped for a brake light and a license plate out. You had Michigan ID card. They actually put you in jail on some fail to appear other warrants. You have $1,846 worth of unpaid fines and costs, including careless driving, driving suspended, old drinking driving. You just got a driving suspended in 2025. Anyway, this charge, they didn't charge with driving suspended. They charged no valid operator's license. It's a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. Carries 2 points on your driving record. How do you plead to that charge?
Not guilty.
I might put you in jail for this. First of all, could you give him a Kleenex? Could take your gum out.
Sorry.
You keep driving and you keep not paying your fine. And normally there's a fine case for driving on a valid license. But I've already given you a bunch of fines which you haven't paid, including the old drinking driving charge from 6 years ago. You still haven't paid that off. from 2020. You're apparently on some sort of payment plan, the kind where you don't make any payment. So normally I wouldn't appoint a lawyer for you. One thing they may do is amend this to driving suspended. That's the accurate charge. The officer gave you a break, but I can't just keep giving you a fine that you don't pay and you just can't keep driving. How'd you get here today?
Off road with somebody.
Where are they?
I was at
Where are they?
in the parking lot.
All right, good morning. Haven't seen you in a while. Let's make sure Mr. Williams didn't drive here. All right, defendant plead not guilty. This is jail possible. So appoint an attorney. Are you working somewhere?
No,
All right, are you still actually living in Sturgis or are you living in Three Rivers?
Sturgis.
I didn't get any of the advice of rights. Did they give you an advice of rights? I don't know what you were doing driving around in Three Rivers at 8:30 at night, but you can't keep driving. So I'll appoint an attorney and I'll set the attorney pretrial for May 1st. Oh boy, that's law day. Gonna be an ugly day. Every year on law day at 9 o'clock in the morning, we have a Liberty Bell Awards ceremony. Probably be in this courtroom this year. Well, it'll be over on the other side. Be right in the middle of Friday morning pre-trials. Not ideal, but we'll make the best of it. I'll set that for 8:30. Who's the person that drove you here?
My girlfriend,
What's her name?
Amber.
She's out in the parking lot?
Yes.
All right, we'll make sure of that. Stop driving. You've got $1,846 worth of unpaid tickets, including an old seatbelt ticket that goes all the way back to 2017. Driving suspended 2020, operating intoxicated 2020, careless driving 2020, driving suspended 21, driving suspended last year. At some point, the chickens come home to roost. So don't make it worse. I also want to see how much you pay between now and when I see you next. I want you to continue to pay on these old tickets.
Yes, sir.
All right, Mr. Williams, I'll take you out to the counter.
Have a good day.
All right, thank you. I'll see you in May. That is not ideal. The April 1st Friday of the month is Good Friday, so the courthouse is closed that day for a state holiday. They may move that, but right now, there was some talk of turning Good Friday into Juneteenth, but that's a Supreme Court holiday, so the courts are required to be closed. I think is the way it works. Anyway, we're not open that day. And Mr. George and Mr. Reed are not available on March 27th. Judge Pattison didn't want me to put everything on April 17th, so I bumped it. It's really going to be a difficult day. And as I said, we usually stop everything and do a ceremony at 9 o'clock.
Well, he laments the day in the future. Good morning once again, everybody. It's TCF Live on a Tuesday where we're dealing with things in real time, but we're making it work. Let's stay in Michigan. We'll go say good morning to Judge McNally.
Good morning, your expert Jonathan Davis.
Your name?
Jennifer Houston.
So it looks like defendant's here for failure to pay $651. How is he going to proceed here?
Judge,
Plus a warrant fee.
what happened with this, he had a case similar to ours in front of Judge Hessen. Looks like he was transferred over to the Wyandotte Court for supervision through their program. In this court, this file was closed out before that one was closed out. He appeared in front of Judge Hessen last October. She gave him 60 days jail, I think, in conjunction with Judge Santos, 27th District Court, to close out that file. We served that time from October 6th until I think it's December 13th. We would ask the court to close this file, time served.
Still got warrants out.
He does their first, days civil.
Can you confirm that? Can you pull that up? Okay.
Oh, November 4th.
Did he ever pay any money on Judge Hessen, the case of, when are you gonna get your life in order?
Soon as I have my license, I'm very close. So
Where do you work?
I've just been working side jobs on Facebook now, and I've done a little bit of work for Mr. Lopez on the side. But on top of that, I've still been going to the guidance center, and they're helping me looking for work as well.
He was supposed to pay $50 bi-weekly on this beginning March 1 of 25. It looks August 1 of 25. He didn't pay anything.
Didn't have any of the money at the time.
Did I not tell you to come and talk to me if you didn't have the money? Did I? Why didn't you come and talk to me? I told you to come and talk to me if you didn't have the money.
I'm still worried about the probation from Wyandotte, and I'm still trying to just follow with everything they wanted me to do. They had me going all kinds of therapy and all the places, rehab for a little bit, left the rehab, and then basically I turned myself in, and here I am now.
This is a 2023 case. We're still fooling around with a 2023 case. You have any money with him today?
He's barely able to keep his residence. He's completely indicating staying on the house.
Why didn't you go and apply for jobs and get a steady job somewhere?
I'd like to, but I mean, it's like pulling teeth. It's like, I know I don't have my license, but I know that I can still have an ID and like be capable of working in a company. But I've just taken my camper now. Got to put my active in that. And, as far as if my mom, she's been there for me, and
What days were you in custody on Judge Hessen's case?
initially I first went in on October 6th, but I didn't see Judge Hessen until November 4th.
And then you were in custody until December 13th.
So it's December 13th. She accredited me 50 days.
You were in custody on Judge DeSanto's case beginning October 6th. Is that right? Kids, wife, anything?
No. So I got my dad. My dad's kind of like, you know, he's got cancer and whatnot. And I see when I started to really just keep myself.
You don't deserve a break, but I'm gonna give you one. I'm gonna just give you credit for time served on Judge Hessens and close this.
Thank
You gotta grow up. You're 39. They don't give us like 487 years on this planet. Good luck. Christina Marie Mathis, thanks. 26F245553. We have seated up here Valdez Hernandez at the table, and then the Earl Agrum seated at the table. My right, your left. Ma'am, your name? You're charged with speeding. Boy, you gotta be careful. You're driving 60 on West Huron River Drive, they say.
I had extenuating circumstances. I didn't realize how fast I was going.
You're gonna plead to impeding traffic, right? Is that charge responsible or not responsible?
Responsible.
160 is your total. You go down to the cashier and make your payment and you're all set. Good luck. Hernandez, Valdez Hernandez. Valdez Brandon Luis Hernandez, 25W840-603 A and B. Your name?
Brandon, Luis Hernandez, Valdez.
You owe $213 on both charges. Do you have the money to pay that?
Yes, I did.
You have $426?
Yes, sir.
The tickets were issued back in October.
I recently got divorced, so I didn't check. Well, I have to check my mail. So. I mean,
I can't hear you.
I didn't check my mail, so when I checked it, I already had the court date, so.
195 on each of these. I'll waive the balance. You can go down the hall and take care of those tickets. Good luck.
Thank you.
People against viral. Abram. 26W841201.
He's on Zoom, Judge.
Okay. You have to start your video, Mr. Abram, or what?
Yes, sir.
Your name?
Just pressing Seco.
So you're gonna plead to no medical waiver card, and then they're going to dismiss. Mr. Seacon, you have to take your hat off, please. And
Okay,
then
sir.
they're going to dismiss the original charge, right?
Okay, thank you, sir.
Is that what you want to do, Mr. Abram?
Yes, sir. Sir,
Mr. Seaton.
All right,
I put him back in the waiting room, Judge.
Mr. Abram, to that charge of no medical waiver card shown, not responsible or not responsible?
Yes,
Responsible or not responsible? You plead responsible to that with the understanding the speeding will be dismissed?
yes, I do. Yes, I do, Your Honor.
Plea is accepted, 170. You can go online and pay that today?
Yes,
Okay, 33court.com, 33court.com with your case number. Good luck.
yes, thank you.
Good morning once again, everybody. TCF Live on a second Monday that I'm trying real hard to make into a Tuesday. Just an FYI for you today, because I normally operate the show off of two computers, and because of an update last night that was found 2 minutes before showtime, I'm only doing it on one. It means my resources are a little more limited today, so we may not hop around courts as much as we normally do. I can only do so much on the one computer. Just a heads up, but we'll see how it goes.
Just slow down. So you want to have an informal hearing on these? They wouldn't dismiss one and let you plead to the other?
I haven't talked to anybody since.
We were back in there talking to the department rep, weren't you?
Mhm.
Yes?
And yes.
That was just now, right? 5 minutes ago?
Yes. And all I said, really, you weren't hearing.
Okay.
I said,
Keep your voice up.
I told him I got the proof to show him to get dismissed. I didn't really want to hear it. I was just gonna show.
Did you have insurance in effect on that day?
No.
Well, then you were still driving without proof of insurance, right?
Right.
Did you have an invalid plate on that day?
To them, yes, I actually had the right tag, so I was confused.
What do you mean you have the right tags?
Like my registration was expired that day, so I don't know.
Do we have a number for Harabedian?
He's in, Courtroom 2. All of us.
Yeah, you have a seat right at the table behind you. I'm gonna call Will and ask them to send him in here. Joanne McNair. 26W841442. You can come up to the podium, ma'am. Your name?
Joanne.
All right, good morning. You're going to plead to impeding, right? Is that what you want to do?
That's okay.
What's that?
That's okay.
All right, to the chair.
They said, I was just have to pay 135.
No, they're not the judge. Don't listen to those guys back there. Okay? I'm not gonna charge you 135. I'm gonna charge you more than that. But if you want to plead to impeding, I'll be happy to take your plea. It's 0 points. It won't go on your record. Do you want to plead to impeding?
That's okay, sir.
Okay, so to the charge impeding traffic, do you plead responsible or not responsible?
Response.
Okay, I'll accept the plea, dismiss the speed 150, and you're all set. Okay? Have a good day. Good luck to you. Jasper Seacon.
He's on Zoom,
Yes.
Judge.
Okay, Jasper Seacon, 26W841410.
Yes,
Good
sir.
morning. Good morning, sir. Your name?
Sorry, sir. My name?
Yes, sir.
Jasprit Singh Sekho.
You want to plead to impeding traffic, right?
Yes, sir.
That's 0 points. Won't go on your record. To that charge, responsible or not responsible?
Okay, sir. Do I have to pay the penalty?
Sir, do you plead responsible or not responsible to impeding traffic?
Yes,
Sir,
sir,
listen to my question. Listen to my
Okay.
question. They're offering you the opportunity to plead to impeding traffic if you want to do that. It's 0 points. It won't go on your record. If you plead to that, they're going to dismiss the speeding. To the charge of impeding traffic, how do you plead? Responsible or not responsible?
Yes, sir. Responsible.
Please accepted 150, speeds dismissed. You can go online and pay that today, 33court.com, okay?
Sir, is it possible? Can you reimburse the waive of the fine because I'm just a driver?
So listen, there's a little bit of a language barrier here. I'm having a hard time understanding you. Keep your voice up. What are you asking me for? Time to pay?
Yeah, I am asking to waive off the fine, please.
To do what?
To forgive the fine, the penalty fee on the ticket, like it's a $150.
I'm not understanding you, sir. You're asking me to waive the fine?
Yes, yes, sir.
Not. How can I do that? I can't do that. I mean, if I do that, I got to do it for the other 100 people in here, right?
Okay.
I can
Okay,
give
sir.
you a week to pay it. Will that help you?
Yeah, okay, sir, it's fine.
Pay this by March the 16th, okay? March
sir,
the
thank you.
16th. Good luck.
Thank you, sir.
Emily Boudry. 26B150326. Officer Harabedian, I'm going to call that case next with this gentleman here. Your name, ma'am? All right, good morning. You're going to plead to impeding traffic. They're gonna dismiss the improper turn. Right?
Yes.
To that charge, impeding, responsible or not responsible. Please accept it. Improper turns dismissed 150 and go down the hall and take care of that. And you're all set.
Able to have, I get paid, on Thursday and I'm able to pay on Thursday.
I'll let you pay on Friday, okay? You can pay on the 5th. Okay?
Thank you.
Good luck. Marissa Glenn. Oh, wait a minute. Before Marissa Glenn, you have a seat at the table. DeAndre Lee Leverett. Come on up here, officer. 26B150339A and B. Your name, sir?
Yeah, I'm afraid of
So your name? So he's saying he's got insurance now, but he didn't have it then. If he pleads to that, do you want to dismiss the invalid plate?
Yes, you're okay.
Yeah, just write it up. You want to do that?
Yes.
Okay, he's gonna write that up differently. Have a seat at the table, John Hindeman. And he's gonna write it up differently. You have a seat at the table there. And then as soon as I get the file, I'll recall it. Officer, you can take these right here. Marissa Lee Glenn, 26T647526. Your name, ma'am? All right, so you're gonna plead to impeding, right? Responsible or not responsible? Please accept it to that charge. 150 is your total, okay? Cash you into the hall to your right. You're all set. Good luck. Whale Dabja. Whale Hussein Dabaja, I'm sorry, Dabaja. 25W or 26W841481. Good morning, sir. Your name?
Well, Elijah?
Good morning. You're going to plead to impeding traffic, right?
Yes.
And then they're going to dismiss the speeding, right?
Understood.
To that charge of impeding, responsible or not responsible?
Responsible.
Please accepted, 150, cashier under the hall to your right. You're all set. Good luck. Thank you. Jaden Lucas Toma. 26T647559A and B. Good morning. Your name?
Good morning, Jaden Toma.
So you have a disregard traffic signal charge. They're going to reduce that to impeding, and then you're going to plead with insurance. True?
Correct.
Is that what you want to do?
Yes.
To the charge of impeding traffic, responsible or not responsible?
Responsible.
To the charge of no proof of insurance, responsible or not responsible?
Responsible.
I don't know who's talking. If you guys could maybe keep it down, I'd appreciate it, okay? Guys, please, whoever's talking. I don't really think you qualify for impeding. I hate to be the bearer of bad news here. This has to go back to Trenton. Tell them they need to figure out something else, please. You're gonna have to have a seat, okay?
Okay.
Doesn't qualify for impeding. Dion? All right, come on up here, Mr. Levitt. DeAndre Levitt, 2CP150339A and B. He just wrote up to dismiss the invalid registration. But you heard what we talked about, right?
Yes.
So I can get him back in here and have him add the no proof, or you want to plead to no proof? I'm going to go ahead and dismiss the invalid plate.
Yeah, I'll put the number.
That charge, responsible or not responsible?
Responsible.
All right, I'm going to accept the plea I'm gonna dismiss file A. Fines and costs are $150, okay?
Yes.
You can go down the home and pay that, you're all set. Good luck. Palacios. Hector Relio Palacios. How you doing? 26 F 245,449. Your name?
Hector Leo Palacios?
All right, so you're gonna plead to impeding traffic, true?
Yes.
Responsible or not responsible for that? Please accepted. Original charge is dismissed. 150 is your total. You can go down the end of the hall and take care of that. Thank you.
Thank you.
Rafael Valdivinos, 26F 2455547.
Good morning, Ryan.
Good morning. So they're gonna have you plead to 5 over, right?
Yes.
That's 1 point. Do you understand that?
No, I thought it was no point.
That's 1 point.
Okay,
Do you want to go talk to him again?
no, I don't need to talk to him. I mean, you brought it down a little bit, so.
All right, have a seat there 1 second. Just 1 second. Can you have one of the court officers, please, at the front there, go talk to and send in the Flat Rock Department rep, please?
Yes, Judge.
Mitchell, Wayne, Collier, Lawson, 26F 245533. Your name?
Mitchell Wayne Collier lost.
So you're pleading impeding traffic, right?
Yes.
All right, to that charge, responsible or not responsible?
Responsible.
Speed's dismissed. Looks like you're getting your act together. Hopefully 170 is your total. You can go down the home and take care of that and you're all set. Good luck.
Thank you.
Doherty Nash. 26 B150097. Or Nash Doherty, is it? I'm sorry.
Okay.
Your name?
Nash Doherty.
All right. Good morning, Mr. Doherty. You are going to plead to, there was an accident. How many times I gotta tell these guys? Do you have any idea? You gotta go, hey, John, wait a second, let's see. Do you have somebody from Brownstown here? That's Flat Rock. Or are you the department rep?
Herbie answer from Brownstown.
Yeah, this has to go to Harabedian. Come on up here if you would. Rafael, Valdivinos. Wait a minute. Yeah, just slide back. Yep. Your name, this is 26F 245547. Your name
Rafael Ladovino.
and your name?
Detective Chakos.
Good morning. Are you new there?
I've been there for a year and a half, yes.
I haven't seen you. I'm sorry.
It's okay.
All right, so listen, he's got a decent record. I was wondering if you wouldn't consider giving him impeding on this. It wasn't outrageous.
Yeah, I'm not unwilling to do that.
Will you write that up for me?
Thank you.
You have a seat right there. Give him a minute, okay? Thank you.
You want to complete the
Thanks.
Sir?
What's that?
You want to complete the motion?
Yeah, you can cross it out on that. Just say plead to impeding and
Okay.
initial it or something. Okay, thanks. Anam Naz.
All right, once again, good morning, everybody. Good to have you all here. I'm starting to make this back into a Tuesday instead of a second Monday. Barbara, thank you for gifting 5 memberships and for the $5 super chat. I very much appreciate you and everything you do for the community, so thank you. Couple things. Tonight, sidebar, 8 p.m. Eastern, 5 p.m. Pacific. Join us for that. Our panel show. We'd love to have you all there. Also, in a moment, I'm going to drop a link into the chat, and it is for a survey. I announced this to channel members on the pre-show this morning. It'll take all of 2 minutes of your time, and I would ask you, if you're a viewer of this channel, to just take a moment and fill it out for me. I'm just trying to understand you guys and where all of you are as we continue to grow, so that we all kind of mesh together. So if you could take a minute and give me your feedback. The survey is anonymous. You need to be logged into Google to take it so people don't take it multiple times. But other than that, I'm not collecting your data or anything like that. Just trying to get your feedback on a few things. So I'm going to drop that link in just a second. But let's move on from Judge Dad, at least for the moment. Let's stay in Michigan, go to Judge Mom.
Mr. Troy Alexander, who is present and standing to my left. Mr. Alexander, please state your name for the record.
Troy Edward Alexander. All right, thank you, and thank you for dressing appropriately for court. Today is the date scheduled for sentencing in this matter, and counsel, did you have an opportunity to review the report and recommendation with your client?
Your Honor, at this time, we did have the opportunity to review the report and recommendation. No additions, corrections, or deletions to be made. We're aware that the recommendation is for Mr. Alexander to be placed on a probationary period for 12 months with no alcohol, drug use, with random testing, to attend and continue on with intensive outpatient substance abuse therapy, continue or attend domestic violence counseling, attend AA meetings 3 times a week. Obviously, no contact with the complaining witness in this matter, not to possess weapons or firearms. Based on the recommendation from probation, we are respectfully requesting this court to adopt that recommendation. And when the court is ready, just a brief elocution on behalf of Mr. Alexander.
All right, and Mr. Alexander, you've been on alcohol and GPS tether since you were arraigned, correct?
Correct.
All right. And so Ms. Placharzik asked for her statement to be read in court. So I will read the statement on the record. On the night of December 20th, I was assaulted by my longtime boyfriend, Troy Alexander, after a 4-hour drinking binge. What began as an argument escalated due to his extreme alcohol use and anger. I did not provoke or consent to any physical violence. I was afraid for my safety and my life. During the incident, he was belittling me and saying that I will regret calling his father for help. Troy then came up to me and punched me in the forehead with all his might. I began to scream and run out of the house. He followed me to my front porch and punched me multiple times in the head. Troy was yelling that he was going to kick the shit out of me. I then ran to my neighbor's house and pounded on their front door for help. As I was waiting for them to open the door, Troy punched me a few more times. 2 of my male neighbors came out and brought Troy to the ground, and then I was able to enter their house for safety. My neighbors held Troy on the ground until the police arrived. In that moment, I felt scared, helpless, embarrassed, and unsure of what might happen next. I feared that if I didn't run for help, Troy might have killed me or beat me up to the point of hospitalization. As a result of this assault, I experienced physical pain, black and blue eyes, a huge lump on my forehead, and emotional trauma. Beyond any physical injuries, the emotional impact has been significant. I've struggled with anxiety, sadness, and difficulty sleeping. I often replay the incident in my mind and feel on edge, especially at night or when I'm alone. This incident has changed how I feel about relationships and trust. Someone I loved and believed would protect me instead caused me harm. That realization has been deeply painful and has affected my sense of safety and self-worth. I'm asking the court to consider the seriousness of this incident and impact
She just muted herself. You know how I feel about judges when they do that. Let me see if I can move us forward a little bit. Nope. Okay. We'll move on from Judge Mom, at least for the moment then. Let's go to Ohio, Judge O'Donnell.
Indict this case and will be pleading guilty by way of information to count 1 with a forfeiture specification in addition to a voluntary forfeiture of U.S. currency, and there's no agreement as to sentencing.
Okay. Mr. Watson?
Thank you, Your Honor. May it please the court, that's my understanding of this morning's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I believe full discovery has been provided. I've also had an opportunity to discuss this matter with Mr. Hopkins. He has indicated to me that he is prepared to enter a change of plea by way of information as just outlined by the state. First, excuse me, by entering a change of plea by way of information, he understands that he'll be waiving his right to have this case presented to the Lake County Grand Jury. Further, by entering a change of plea, he understands that he will be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
All right. Mr. Hopkins, how old are you?
33, Your Honor.
And how far did you go through school?
I received a GED.
Are you a U.S. citizen?
Yes, Your Honor.
Are you able to read, write, and understand the English language?
Yes, Your Honor.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
Yes, I take prescription medication.
What have you taken?
I take gabapentin and Cymbalta. And
what do you take that for?
multiple sclerosis.
When is the last time you took any of that medication?
9 o'clock yesterday, last night.
All right. Does it affect your ability to understand what's going on here?
No.
Did you get a copy of this information that was filed?
Yes, Your Honor.
Do you have any questions about it?
No, Your Honor.
You understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict you.
Yes, Your Honor.
Did you discuss that right with your attorney?
Yes.
And are you going to waive that right?
Yes.
Just need to sign this. It's just a waiver of indictment that we talked about.
Your Honor, I've witnessed Mr. Hopkins and Mr. Watson send a waiver of indictment and that is sent myself.
All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, stop me. If you want to talk some more to Mr. Watson, let me know and I'll give you more time. Do you understand that?
Yes, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have a constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order that's called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes,
Are
sir.
you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, Your Honor.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to this charge?
Yes.
You understand by pleading guilty, you're fully admitting your guilt to this charge.
Yes, Your Honor.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
Possession of cocaine is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
If you plead guilty to the forfeiture specification, you're voluntarily giving up those items listed. Do you understand that?
Yes.
All right. Do you understand that your guilty plea may result in a driver's license suspension of between 6 months and 5 years?
Yes.
You understand your felony conviction will prevent you from owning or possessing a firearm?
Yes.
You understand if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority.
Yes, Your Honor.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violated any conditions, I could send you to prison for 12 months. Do you understand that?
Yes, Your Honor.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No, Your Honor.
You understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer.
Yes, Your Honor.
Have you had enough time to talk to Mr. Watson before pleading guilty today?
Yes, sir.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No, Your Honor.
All right, Ms. Gold, if this case went to trial, what would the evidence show?
Thank you, Your Honor. The facts would show that on January 23rd, 2026, officers searched the defendant's car in Wickliffe, Lake County, Ohio, after believing that he had trafficked cocaine. During the search of the vehicle, officers found suspected cocaine, which was taken to the Lake County Crime Lab and tested positive for less than 5 grams of cocaine, a Schedule II controlled substance.
All right, thank you. Mr. Watson, anything to add to those facts?
No, Your Honor.
Mr. Hopkins, did you hear what Ms. Gold said, that the facts would show if the case went to trial?
Yes.
Are those facts true?
Yes.
And what is your plea to possession of cocaine, a felony 5?
Guilty, Your
What
Honor.
is your plea to the forfeiture specification?
Guilty. Guilty, Your Honor.
Mr. Watson?
It's the same form we went over. He just added that you're taking cement. So you just need what information? Medical stuff. This doesn't know how to screen. Yeah, there's cameras. 3/3/26. It's not live stream, but there are cameras. I mean, somebody could watch it. That's up to you.
Your Honor, I've witnessed the defendant and Mr. Watson sign the written plea of guilty, and I signed it myself.
Mr. Hopkins, is this your signature on the written plea of guilty?
Yes, Your Honor.
And did you sign it voluntarily?
Yes, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, I do.
Accept the written plea of guilty. Defendant was present. Mr. Watson advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept his plea of guilty and find him guilty of possession of cocaine, a felony 5, and the forfeiture specification. I'll refer this for a pre-sentence report April 8th. At 8:30 will be the sentencing. The bond is revoked. Anything else, Ms. Gold?
Nothing from the state, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
All right, we're adjourned.
Thank you.
Okie dokie, friends. Let's go down to Florida, checking on Wade Mercer.
Others in the courtroom, you're accused of one count of lewd lascivious battery. This is a second-degree felony. Mr. Thomas, there is probable cause in the complaint. The only thing I see on your history was a burglary that was dismissed from Bay County 2 years ago.
Yes, sir. That's
A
from
little
my
over 2 years ago. Sir?
That was from my juvenile about when I was 17.
Okay. So you have no history as far as I'm concerned. The problem is you got a very serious charge. Where do you live at?
I live in Gulfport, Mississippi.
Are you a student? Are you employed or neither?
I'm employed.
What do you do for a living?
Landscaping.
Time or part-time?
I was finna go to full-time, but then I got caught up here.
Okay. And my understanding, Mr. McDaniel, his mother's in the courtroom, and she told us, right, she brought him over here to turn himself in to try to get this case resolved. So that implies he's not a flight risk. Mr. McDaniel, anything on behalf of Mr. Thomas?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
So, Mr. Thomas, I'm not going to give a conditional release on a second-degree felony, but I'm also going to be aware of your criminal history and the nature of the offense. The allegations are not necessarily that it was consensual from his perspective, it was, but from her perspective, it was slightly different. But the allegations are what they are. So, Mr. McDaniel, does he prefer a cash bond or a surety bond? Or have you had a chance to talk to him about that?
Cash bond, Your Honor.
Mr. Mitchell, any objection?
No objection.
Okay, so Mr. Thomas, I'm going to set you a $500 cash bond. That's normally what I would do for a third-degree felony, but I am taking into account the allegations against you as well as your criminal history or lack thereof. So it's $500 cash, ma'am. Because his history is so good and because of the allegations, it's a $500 cash bond. Now, you do have a condition of no contact with the alleged victim, no contact at all. No telephone contact, no in-person contact, no electronic communications, text messages, nothing. So just no contact at all. And let me see if your mom has any questions. Ma'am, do you have any questions? So as soon as the $500 cash is posted, he'll be released. It's got to be posted at the jail. And I just need to keep him away from her. We're also going to ask the jail to give him his court date. They'll give him that notice before he leaves. It'll be April 7th. April 7th at 8:30. Any questions, ma'am? His question is going to be, and I appreciate you turning him in. That's a big factor with a Mississippi address. You turning him in is a big factor to me. I knew there was some local ties, but I wasn't sure if he had never lived here. He lived in Panama City. You turning himself in so quickly is one of the factors I consider for bond purposes because it indicates he's not a flight risk. Okay. Mr. Thomas, your mom doesn't have any questions. Do you have any questions?
Nah.
All right. Wish you the best, sir. Thank you for coming, ma'am. All right. We have, Mr. McDaniel, we have Chakisha Dixon's mother here. So let me see her next, please. Miss Dixon, your mom is in the courtroom. Miss Dixon, you're here because you have a trespass case, ma'am. I'm appointing the public defender's office to represent you. Please listen to Mr. McDaniel.
Your Honor, I spoke to Ms. Dixon. We're going to plead no contest. The charges listed. You understand it should be sentenced 10 days in county jail, credit for 10 days, $370 fine. She has signed her plea waiver form, waived the right to jury trial, and called witnesses. This is resolved this case this morning.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
And in the courtroom, ma'am, do you have any questions? She's got 10 days in jail, but she's already served it. Okay, so she's through with the jail sentence. She gets out of jail. There's a court cost and fine set by state and county law, and it's $370. And if she doesn't pay it, she doesn't go to jail. If she doesn't pay it, the clerk's office has to give her a certain amount of time to pay it. And if she doesn't, they suspend her driver's license under Florida law. So it's $370. It'll go to a collection agency, and then they'll suspend her driver's license if she doesn't pay it. But she can't go to jail for not paying it. They'll put a suspension on them. She won't be able to get one. Okay. Any other questions, ma'am? And Ms. Dixon, is this the plea you would like to enter?
Yes, sir.
Ms. Dixon, I'm going to accept your plea of no contest to the charge of trespass, ma'am. I don't remember the facts of this case. It must not have been must not have been much to it if I agreed to 10 days. I don't doubt that at all. I'm just curious what the allegations were. She must not have been like in a parking lot or
The hotel.
that's it. It was a motel room where I remember now. Okay. Yeah, I remember the allegations. It was a motel room and allegedly she went in the room to get her belongings after the officer told her not to. Okay. That makes sense. So Ms. Dixon is 10 days in jail, credit for 10 days, ma'am, $370 court costs and fines. That'll be in the civil judgment. Ms. Dixon, you're going to be released today. I need you to stay out of trouble, Ms. Dixon. Any questions?
No, sir.
Ma'am, any questions? She can be picked up at the jail. Your mom's going to pick you up. Is that right, ma'am?
Okay.
Your mom's going to pick you up. Okay. Have a good day.
Okay.
Yes, ma'am. Mr. McDaniel, that's it for friends or family. So we can go back to the top of the list, which is Melinda Wagner.
Thanks, sir.
Ms. Wagner, good morning. Ms. Wagner, you're here because you've been accused of one count of grand theft between $750 and $5,000. Let me clarify, between $750 and $5,000. And Ms. Wagner, there is probable cause in the complaint. Your criminal history is very lengthy, but I still think you're entitled to a bond because it looks to me like you're not on probation. Is that accurate, ma'am?
Yes, sir. That is accurate.
And you're also you don't have any charges pending as far as I can tell. Is that right?
That's right, sir.
That's perfect. That means you're entitled to a bond. I'm going to listen to the attorneys before I set that bond. Mr. McDaniel, anything?
Your Honor, we just asked for a reasonable bond or a cash bond, whichever the court wants to do.
Mr. Mitchell.
If she wants to pay a cash bond, we don't have any objection to that.
Ms. Wagner, when there's allegedly restitution owed, I'd prefer a cash bond if the parties agree to it. So I'm going to set your bond at $500 cash.
Yes, sir.
As soon as you post that bond, you'll be released. Ms. Wagner, you have a condition of no contact with the alleged victim at all. Ms. Wagner, do you have any questions?
No, sir. Thank you, sir.
Yes, ma'am. Have a good day.
You too, sir.
Yeah, the jail's going to give you a notice for April 7th. Ms. Wagner, 8:30, that'll be your court date before Judge Garcia.
April 7th, sir?
April 7th at 8:30 will be your court date. Yes, ma'am.
Yes, sir.
The $500 for the cash.
Yes. Next is Terrence Farnell. Mr. Farnell, good morning. Mr. Farnell, you're in jail for a hold out of Polk County. You also have a pending charge here that you're not in jail for. I'm appointing the public defender's office to represent you in both those cases, at least for first appearance purposes in the Polk County case. Listen to Mr. McDaniel and we'll see where we go, sir.
Your Honor, I spoke to Mr. Farnell. He wants to enter a plea of no contest. The charge is listed locally. I understand he's gonna be sentenced to 4 months in the county jail, 22 days jail credit, $400 fine. And, he is waiving his right to a jury trial and call witnesses and that'll resolve this case today.
Mr. McDaniel, I think you told us yesterday that he'd already been held for this county for some period of time. They did not pick him up. Is that right?
Yes, sir.
No, that's not correct. I think Jake had asked for a hold, but they never placed one. He had a court date that he missed on the 20th. Ironically, he bonded out from here on the 20th, but there's still a warrant for him in that other county. So that's kind of where we're at.
Okay, thank you. And the warrant is for failing to appear on that day that he bonded out?
Correct.
Okay.
But I kind of explained to him, there's still chances that they may still revoke his bond when he gets down there because he got discharged here and,
Yes, sir. That makes sense. All right, thank you. Thank you for explaining that. Mr. Farnell, did you hear that agreement, sir?
Yes, sir.
And is that the plea you would like to enter to go ahead and resolve the local charges?
Yes, sir.
Mr. Mitchell, is it agreeable with the state?
Yes, Your Honor.
Mr. Farnell, I'm going to accept your plea of no contest to the charge of driving while licensed suspended or revoked knowingly. I'm going to judge you guilty of that offense, sentence you to 4 months in jail, give you credit for 22 days you've already served, excuse me, impose court costs and fines of $400. Mr. Farnell, you'll get a chance to work that all through the jail. You also very well may get some extra gain time. I hope you do. When you get down to a couple of weeks left on your sentence, I'm going to ask the jail to go ahead and notify Polk County to pick you up. So you may actually finish this sentence in Polk County. The other thing I'm going to ask the jail to do is give you documentation of the dates you were in our jail. Because if they do pick you up and you get down there, I want you to have that documentation to be able to give to your lawyer. Like Mr. McDaniel said, if this charge happened after you're on bond, they may revoke the bond down there. But if it didn't, they need to know that you were in jail. That's why you missed court. So we'll give you that documentation, and you may actually finish this sentence while you're finish our sentence in their custody if they want to pick you up. We usually hold them 15 days for an in-state warrant. So, Corporal, if y'all will notify Polk County, they can pick him up 15 days before his EOS.
Yes, sir, sure will.
And that way, and if they haven't picked him up by his EOS, bring him to first appearance, because if they've had the 15 days and they haven't picked him up, we'll address it then. So I want to see you when you finish your sentence if you're still here. Any questions,
Yes,
Mr. Farnell?
Yes, sir.
Wish you the best, sir.
John Brown.
John Brown. Mr. Brown, good morning. Mr. Brown, you have a hold out of Miami-Dade County. Looking at the paperwork they've sent, the charges are some type of insurance, fraudulent insurance claim, a grand theft, and they say no bond. Now, Mr. Brown, sometimes that means no bond indefinitely. Sometimes it means no bond until you get to that county. All I can tell you is right now they're saying no bond. When you get to Miami-Dade County, you'll go to another first appearance, and the judge there will determine if you're entitled to a bond or not. Right now, you don't have a bond. Mr. Brown, if you're still here in 15 days, you'll come back to first appearance. I'll ask what the status of the transport is. It's certainly possible you won't be here in 15 days. It's certainly possible you'll be on your way to Miami-Dade County. You may be there already by then. Do you have any questions?
Judge, I'm just gonna let you know, I advised him, so he's looking confused, and I told him it wasn't gonna come up at first appearance, but the state filed a motion to quash that yesterday. They got a hearing this morning at 8:30 to quash that writ, so that warrant, so I mean, the odds are he's gonna be getting out today or tomorrow. I don't think they're coming to get him.
Thank you, Mr. McDaniel. Mr. Brown, if that happens, I won't see you at all. If we get something from Miami-Dade County in writing saying they don't want you, you'll be released immediately. Any questions?
No, sir.
All right, sir. Wish you the best. And we have Travis Sangster. Mr. Sangster, good morning. Mr. Sangster, you're here because you've been accused of one count of disorderly conduct, breach of the peace. Mr. Sangster, there is probable cause for that charge. Mr. Sangster, I'm going to appoint the public defender's officer to represent you. You have a separate charge you had for arraignment scheduled yesterday, and I don't know what that charge was.
Misuse of 911 services.
So you have a second charge of misuse of 911 services. Right now, you're not in jail on that case, though. I'm going to appoint the public defender's officer to represent you in both cases, and we're going to listen to Mr. McDaniel first. See where we go. Mr. McDaniel.
We just asked for reasonable bond.
Mr. Mitchell, yesterday, the state had made the stating that y'all may be asking to revoke his bond in the 911 case. What are y'all decided to do in that?
That is correct. If he doesn't want to take the offer today, the state will move to revoke his bond in case number 2676 MM.
2676 MM. And that charge is what?
Misuse of 911 services.
Okay. Mr. McDaniel, would you like to be heard on the state's motion to revoke bond?
No, Your Honor. So what's happening? Am I getting set on bond today?
Just a second. I'm looking at it, Mr. Sangster. I'm trying to decide whether I want to revoke your bond or not. And I really want to read the misuse of 911 call. So give me a second, case, not call. Give me a second to go back and look at that, and let's see what the allegations were that you were in court for yesterday. I'm familiar with the allegations from yesterday. I'm not familiar with the.
Well, Your Honor,
the prior. Give me just a second. I'll be glad to listen to you, but let me read the complaint first, Mr. Sangster. Okay.
Yes, sir.
I just want to see what you're accused of, what you were in court for originally, and see what bond was set and so forth. So that's going to take me about 60 seconds, probably. Yeah, okay, I remember it now. Mr. Sangster, I would suggest you don't talk about what you're accused of. If there's something you think I need to know for first appearance purposes, I'm glad to listen, sir.
You got it. You're doing a great job, Your Honor. Judge, I think the 911 call, I guess I would make a statement, was, more about mental health, and I guess, there was, the sheriff's office was assisting him. I know that I've, been contacted about it, and, I think he was trying to get some assistance for mental health, and that's when they wouldn't help him, I guess. It was kind of an explosion, but the original 911 call was for some kind of mental health assistance.
Yeah, and what because I'm a witness to the behavior in the courtroom yesterday, I don't know if I should go ahead and recuse myself now, but then he won't get a bond set. I'm not going to rule on the motion to revoke bond because I really think that may be inappropriate given the fact that I was a witness to the disorderly conduct. So let me do it this way because I want to make sure that another judge makes that decision. I'm not going to revoke your bond. What I'm going to do is I'm going to order that you be held until tomorrow because I want another judge to make that call, not me. I am going to file a recusal in both cases today, Mr. Sangster. So tomorrow you'll come up. You've got a bond that was set. The judge tomorrow, whoever that is, and they may do it today. I'll file the recusal today, but tomorrow at the latest, either today or tomorrow, some judge is going to first appear you, and then they'll decide whether they're going to revoke your bond. So, Mr. Mitchell, you may want to file a written motion or not. That's up to y'all. But I just don't think it's appropriate for me to be a witness to the new charge and then be the same judge to make the decision on whether that your bond's going to be revoked when that's the basis for the bond revocation. So, Mr. Sangster, you're going to see a different judge either later today or tomorrow. Any questions, sir?
Oh, Your Honor, thank you.
Wish you the best, sir.
You too.
So I'll file that recusal today after first appearance. Mr. McDaniel, it's everything I had on my list. Anything else from the public defender's office?
No, Your Honor.
Mr. Mitchell from the state.
Nothing from the state, Your Honor.
Ms. Williams, I missed anything? All right. Ladies and gentlemen, that concludes our first appearance.
Okay, Austin asked in the chat if what Judge was referring to, if that happened on stream yesterday. It didn't in what we showed. We showed his first appearances, but then he had a misdemeanor court after the fact yesterday that we did not show, so my guess is it happened during that docket. That's my best guess anyways. Let's go back up to Michigan, back to Judge McNally.
Go home. I have the charge here. That indicates as follows. You can give me 1 second. That you fail to refrain from consuming alcohol or drugs, specifically testing positive for alcohol at a tested DNA on February 9 to 26. If you plead guilty or if you are found guilty, you could get 5 days on this. Do you understand that? Did you sign an advice of rights form here today? Did you read it and understand it? If you plead guilty, you'll be giving up all those rights on the advice of rights, and we will not have a hearing. Do you understand that?
Yes, sir.
You have the right to a lawyer. If you would like an attorney, I will provide you with non-public expense. Do you understand that?
Yes, sir.
Would you like a lawyer?
Yes, sir.
I'll enter a not guilty plea. I'll set you up with a lawyer, and we will have a revocation hearing after you confer with the lawyer. Okay? Any questions? All right, go right out in the hallway, and he'll hand it to a lawyer. Nash Shorty, 26B150097. Your name? So he added what he needed to, because I don't take these unless the damage to the other vehicle is not major and there's no injuries, but he wrote that down, that there was no injuries, no disabling damage. So you want to plead to impeding? Who's with you?
My mom. This is my first time here.
Well, if you plead to impeding, it's 0 points. It's not going to go on your record. Is when there's an accident, they have to fill out a report and it's sent to Lansing, and your insurance carrier is likely to find out about it anyway. I just want you to be aware of it. You understand that?
Yeah.
Do you want to talk to your mom? To the charge of impeding traffic, responsible or not responsive?
Responsible.
All right, you got to be careful. I'll accept the plea. Dismiss the failure to stop, assured clear distance. 195 is your total. 195 is your total. You go down the hall and take care of that. Thank you. Andrew Pignataro, 26W, 841396. Good morning, sir. Your name?
It's Andrew Pignataro.
You're going to plead to impeding traffic, right?
Yes, sir.
Same thing. It's just no injuries, minor damage. To that charge, responsible or not responsible?
Responsible.
Failure to stop, assured clear distance is dismissed. Please accept it to impeding. 195 is your total. You are all set. Good luck.
Thank you, Your Honor.
Thank you.
Barbara, thank you for the $5. I very much appreciate it.
26T647156. Your name?
Go Frank Bean the second.
You're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible to that? Were you related to any of the Spinas in Trenton?
My dad used to clerk for you, sir.
Yeah,
Years ago. Wisest man I ever knew.
he was great. I loved him.
Yeah.
He was one of my volunteers. He'd take files down there.
Yeah,
Wow.
I know.
He's been deceased quite a few years now.
Yeah, well. Quite a few,
I
yeah.
liked him a lot. He was a good man. To the charge impeding traffic, responsible?
Yes, sir. I was a momentary lapse of reason. I got lost. I grew up in this city, you know.
155. You're all set. Have a great day.
You too, sir. Thank you.
Thank you very much. Booth, Robert Aitken, Sunday Booth. 260-645-762 A, B, and C. You're taking a long way home, eh?
It looks like he has an attorney.
Did you have an attorney?
I don't know where it went. He was talking about us. You that, Bob?
Okay, well, I'm gonna put this aside then. I didn't know you had a lawyer. Kelly K. Banya the first. Banya. The first? Is that what it says? Kelly K. Banya. 260-647-683. Your name? All right, you're going to plead to impeding traffic, right? Responsible or not responsible to that? Okay. All right. To the charge impeding, do you plead responsible? Please accepted. 165 and you're all set. Cash, you're into the hall. You're right. Best of luck. Who's writing that up to change yours?
Maybe it's in there.
Oh, Rafael Valdivinos. 26F245547. Okay. Sorry to keep you waiting. Your name?
Fine.
Your name?
Rafael Latinos.
Ah, you're gonna plead to impeding, right?
Yes.
Responsible or not responsible to that?
So,
All right. 1 second here. $165, cashier end of the hall to your right. And I'm gonna go ahead and, no insurance was just a warning, by the way. You knew that, right?
yeah.
So you can go down the hall and take care of that and you're all set.
All right, friends, let's change it up. It looks like Judge Stevens is getting his day going. Let's check in down in Texas.
45
CR 138. And it looks like two cases on the same day, October 1st, 2024. Third degree felony of unlawful possession of a firearm by a felon. The problem with that one, of course, is you're an habitual felon. So if you're convicted of this because you got the burglary in 01, then after that, a burglary of a habitation in 2011, after that, assault on a public servant in 2018. And let's see, you got the 2018 was used to make this case unlawful possession, but you have two other prior convictions in 01 and 011 that bump this third degree felony to a minimum 25 years imprisonment to life, habitual felon on that case. In the 25 CR 139, that's a state jail felony of theft because you have two prior theft convictions out of county courts at law. Every time you steal a pack of gum, it's a felony offense because of the two prior theft convictions. Any theft afterwards is a felony, a state jail felony. But then there's that burglary in 01, 011, 2011, 2018, and two of them in 2018. So this state jail felony gets enhanced to a second degree felony punishment, I believe.
Yes, sir, that's correct, Judge.
So you're looking at 25 to life in one case and up to 20 years in the other case. What do we do today? What are we going to do?
Judge, considering the gravity.
Yeah.
The extreme.
It's grave.
Extreme gravity of the case. What I would ask is, I do have the that's the downloads they sent me. I want him to put videos. Can he come in tomorrow before he makes that decision?
No, we're gonna go one way or the other. Y'all can get ready. But if y'all don't have an agreement reached, we're gonna default to trial and we're gonna just try it. We're gonna try the unlawful possession first.
What the offer, I believe, was 10 years in the pen. And I did tell him about the offer, so he knows what the offer is.
Well,
and when I talked to him, he said he didn't want to take.
Okay, then I don't accept the deal. No deal after today. So we're just going to move on, set it for trial on this firearm by a felon and no deals. That's it. Okay, that's Mr. Pollard. Okay.
Give the reset right now.
DeQuan Pugh.
He's here, Judge.
Move that one fast. Please, we're gonna pick that quickly, okay? DeQuan Pugh.
Just Mr.
25 CR 1471, you're charged with the second degree felony of aggravated assault.
Just to my understanding, Mr. Pugh, who doesn't have any felony history, he has been to my office. I did convey Mr. Boyd's offer to him, which was 12 years in the pen. And I am aware that the victim wants pen time.
So what are we gonna do?
What I offer was 12. I was hoping.
He's looking at 20 years.
Right.
20, and then this is a deadly weapon, so you have to serve at least one half of your time. If you're sentenced to 20, you got to do 10 flat.
Right, Judge. And to my understanding.
Before you even considered for parole, much less get it.
Right. And to my understanding, from talking to him, in my office, he has no prior criminal history. Not criminal history, prior felony history, right? You know what I'm saying? He's never been convicted of a felony in his life.
So you're got a point. Go ahead.
Well, and like I say, I know that the state's office was 12 years.
It's aggravated assault. That jury isn't eligible to give him
Yeah,
probation.
jury can give,
Oh,
you
can
can
they get
give
him?
him straight, you can give him deferred, but you can't give him straight. Jury can give him. straight probation.
Gives regular
Yes.
probation on a
Yes.
firearm?
Yes.
Go ahead.
Like it's possible to resolve the case with some type of probation, but I understand the state can't do that. So, but he does not have any prior felonies at all.
Make it a cap. And you can plead him unagreed as a judge with a cap. And you think it's probation, he'll give probation maybe. Up to you.
But like I said, he is aware of the 12-year offer that was made to him. So what he's saying is he'll change that offer now to a 12-year cap. But
I'm turning this off so everybody can hear this.
And he's muted himself.
It defaults to trial, set it for trial.
It's Erica's case now, so if we try to talk her into something different, can.
okay, I'll see what I can do with it. Thank you.
Set it for trial, please, on the child docket. Thank you.
That's another possibility. Okay. All right, next week, yeah, when that, Wednesday, 4 o'clock. But. Let me go talk with him.
I'll give you a copy.
If they, and make sure he understands, he's looking at up to 20 years in prison. If they sentence him to more than 10 years, they can't probate it.
Right.
A jury cannot grant probation if it's a day over 10.
All right, friends, let's stay in Texas, but we'll go say good morning to Judge West.
He has a conviction.
There's two. There's an assault to 3rd degree from September 11th of 2019 in the indictment, and then a prior one, attempted robbery 3rd degree, March 28th, 2013.
Yeah, I was looking at the unlawful possession of a firearm indictment. I don't know that both of those are priors were included in that particular.
No, it's not. It's not, Judge. It's just as one of them in that case. I looked at.
But if there are, you would
Right.
file that
I would,
notice,
right.
so it would be considered habitual, correct? Okay.
Eventually I will.
Okay. All right, so are you Kendrick O'Veal?
Yes, ma'am.
And Mr. O'Veal, in cause number 25 DCCR 1776. Sorry, it's taking. You are charged with evading arrest or detention with previous conviction, and that's from August 31st of 2025. That shows that you were previously convicted of evading arrest or detention July 22nd of 2011. So that's what makes it a state jail felony. Then the indictment further alleges you were convicted of attempted robbery, a third-degree felony, March 28th of 2013. And after that was final, you were convicted of assault, a third-degree felony, September 11th of 2019. And so what that means in that case is that if you go to trial and you're found guilty, and those prior convictions are true, the range of punishment would be enhanced to a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yeah.
And then in cause number 25 DCCR 1777, you're charged with unlawful possession of a firearm by felon. And that is from August 31st of 2025. That indictment alleges one prior felony conviction, the one from 2019, but the state can file, and I anticipate they would file, a notice of enhancement because that 2013 was left off of that indictment. And so what that means in that case is if you're found guilty and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or the rest of your life. Do you understand? And then finally, in cause number 25 DCCR 1778. Once we get all these done. You're charged with the third-degree felony offense of deadly conduct, discharging a firearm from that same date of August 31st of 2025. It does allege those two prior felony convictions. Again, what that means, if you're found guilty and if those prior convictions are true, you would be considered a habitual offender in that case also, with a minimum punishment of 25 years, up to 99 years or life in prison. Do you understand? In all of those cases, I have here on this tablet a plea bargain rejection in each case that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your cases, to go on, probably it looks like counts 1 and 2 for a 15-year term instead of that habitual. And so in 2 of the cases, a 15-year term, and then in
It's 15 on all, concurrent on all of them, Judge. Yeah, because it's state jail is at
oh, I opened the wrong one. Sorry. Hold on, y'all don't want me to do that. That's a 30.
Oh, that's my next one.
Sorry. Okay, so 15 years in all 3 cases that would run concurrently, which means together at the same time. Do you understand what the state has offered you?
Mhm.
And so you have every right to reject that offer and have all 3 of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty in your cases. And do you understand all of that? And do you want to reject those offers and have your cases set for trial? All right, we'll get that done. I do want to, is there any reason to believe that these offers would change?
Not at all, Judge.
So, Mr. Oville, I want to make sure you understand that after today, unless there is new evidence that is discovered by either your attorney or the state's attorney, I will not accept these plea agreements again. Once it's on the trial docket, it either goes to trial, you can plea open to the court, or to some different amount or negotiated punishment. Do you understand? Okay, so I will get your cases set for trial. Mr. Oville, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, so Mr. Parker, you're released. Mr. Oville, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Thank you.
Thank you.
Okay, real quick, Great Granny was asking in the chat about the different colors of jumpsuits that the prisoners wear. Now, this varies from jail to jail, but the color coding has to do with multiple things. It has to do with the person's security level. So if they're in secure housing as opposed to gen pop, that can make for different colors. It in some areas has to do with whether they have been sentenced or they are unsentenced. So that can make a difference. There's also like a health status involved. For example, if you go to San Antonio, Bexar County, and you look in Judge Boyd's court, you'll sometimes see women in yellow, and it's because they're pregnant. So there's a lot of different reasons that the coding happens, but basically that's the gist of it.
Mr. Walker, in cause number 26, DCCR 0082, you're charged with a first-degree felony offense of injury to a child from December 16th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the minimum punishment is 5 years, up to 99 years or life in prison. Do you understand? And I have here on the tablet a document called the plea bargain rejection that has your signature on it with Mr. Parker's. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty in your case for a 30-year term in prison. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to enter a plea of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Nicholas, is there any reason to believe that, are you waiting on any evidence?
Judge, that offer is based on the injuries sustained by the child, a 1-year-old with facial fractures and lacerated liver. I need to get some follow-up medical records to see if that condition has improved or if it's going to be a permanent injury situation. That offer may get worse depending on what I find.
Okay, so I do want to make sure you understand, Mr. Walker, that after today, I will not accept this plea agreement unless there's some new evidence that comes to light from your attorney or the state's attorney. Do you understand?
Yes, ma'am.
All right. And so also Mr. Parker's been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Parker, you're released. Mr. Walker, we will appoint someone today and they should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff.
We have Bill, but it's a shame here. Yeah, you know. No, door.
Who?
Bill. It's just.
Okay, and everybody knows we reset Relicia Mouton for Mr. Rojas. Let's see, Mr. Bruce Smith on Michael Ray Martin. Michael Martin. Morning. You all right?
That's how you're doing, Bruce.
I know.
The third day I've had woke up with low grade fever. It just takes forever to get rid of it.
Good morning. Are you Michael Martin Jr.?
Yes, ma'am.
This is 25 DCCR 1831 and 1832. Mr. Martin is charged with evading arrest or detention with the use of a vehicle and aggravated robbery. And Mr. Smith, what is the announcement?
Yeah, I'm asking for another. I was out all last week, but there's like 9 or 10 videos. I've had the discovery for a couple of weeks, and I just haven't had time to go through it completely.
Sure. So I'll just do a normal reset. Mr. Martin, that'll give Mr. Smith time to go through everything, bring it out to the jail, go through it with you, and then we'll see if we can get an announcement. All right, you can go back with the paper. Thank you.
Thank you.
Yes, sir. Thank you. Have we heard from Mr. Wilkerson? Right. And what about Brittany or Marvin? Brittany back there working on stuff. Okay, and what about Marvin? Is he back there working on stuff too, or?
Mr. Lewis.
Okay. All right, Mr. Kelly
Yes.
and Mr. Coleman, let's go ahead and take care of Dondre Blewett. Morning, you are Dondre Blewett.
Yes.
And so we've got two cases here. We've got cause number 22-41150. And in that case, get it pulled up, please. Mr. Blewett is on probation and all right, so it's an evading arrest or detention with the use of a motor vehicle, third-degree felony. It looks like placed on probation September 13th of 2023. And that was an 8-year deferred probation. There is a first amended motion that's been filed. It alleges, looks like a new offense of aggravated assault with a deadly weapon from February 1st of 2026. Out past curfew, committing an offense of harassment, February 1st of 2026. Avoiding injurious or vicious habits by brandishing a loaded firearm during the assault of Ms. Cantu on February 1st, 2026. That he brandished the firearm at the residence where a child was present, same date. Associated with a disreputable person, Mr. Daniel Clark, who was at that same location during that offense or alleged offense. Failed to immediately report that arrest for the aggravated assault with a deadly weapon to the probation officer, was intoxicated or under the influence of an intoxicating substance on that date, possessed a firearm and ammunition in violation of probation on that day. And Mr. Kelly has filed a motion asking that I set bond in that case. And at this time, is there any bond set?
There's no bond set in the MTRP, Your Honor.
Okay.
And the bond in
Yeah.
the new indictment is $800,000.
Right, so in cause number 26 DCCR 0632.
And if I may, Judge,
Hold on a second.
thank you.
In that case, Mr. Blewett is charged with aggravated assault with a deadly weapon, second-degree felony, and that's from that February 1st date in 2026. And so the $800,000 bond was attached to that case by the magistrate when he was indicted. And Mr. Kelly has filed a writ in that case asking for me to reduce that bond.
Right, and if I'm not mistaken, Mr. Blewett had originally posted the bond after that February 1st arrest. He has not been incarcerated since February the 1st. He was released from Jefferson County Jail, I think on February 3rd or 4th after that initial arrest.
Through accusation or through making the $800,000 bond?
That's correct.
He got out on accusation, so he hasn't made a bond in any.
That's correct. The new allegation, the aggravated assault case, was refused by the DA's office. We then attempted to resolve the MTRP case, we meaning myself and the state's attorney, Mr. Coleman. That case, I won't speak for Mr. Coleman, but procedurally, this is what happened. That case was then presented to the grand jury last week and indicted.
Okay.
So procedurally, that's where we go.
And so do you have a witness or witnesses for your motion?
I'd like to call Ms. Stelly, Judge, if I may, Officer Stelly.
Sure. Good morning, ma'am.
Good morning.
Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. And you can step up just a little bit. All right, go ahead.
Thank you, Judge. Officer Stelly, would you state your name for the record, please?
Deshauna Stelling.
How are you employed?
Jefferson County Adult Probation.
Okay, and how long have you been at probation?
Approximately 1 year and 4 months.
How many folks are you currently supervising?
150.
Is Dondre Blewett one of those people?
Yes.
Okay. How long have you been working with Mr. Blewett?
For the 1 year and 4 months.
Oh, yeah, since you've been here.
Yes.
Did you inherit his case from another officer?
Yes, sir.
Is that a normal thing that happens?
Yes, sir.
Okay. Would you tell the court, please, you can estimate, or if you know the actual number, how many specific meetings as Mr. Blewett's officer have you had?
Maybe 10, roughly 10 or 11. We do it every other month.
Every other month.
Yes.
Is it customary for folks that are on felony probation to only be required to meet every other month?
And they're in compliance, yes.
Has Mr. Blewett been in compliance up until this alleged new offense?
Correct, yes.
Okay. When you meet with him in person, those meetings are in your office? Is that
Yes,
correct? Okay. Is he on time for those meetings?
Yes.
Can you recall any situations where he has been late or kept you waiting?
No, sir.
Okay. Has he been respectful to you during those meetings?
Yes.
Has he been respectful to other staff in the probation office?
Yes.
Has he been subjected to drug testing while he's been under your supervision?
Yes.
Can you tell the court how many times he's failed a drug test?
He has never failed any drug test.
Has he been subject to any other kind of chemical testing?
No, sir.
Okay. In terms of other things that he's required to do or that he's been required to do while he's been under your supervision, because you mentioned that he has otherwise been in compliance. I'm not addressing the February 1st issue yet. What other things has he been required to do other than not test positive for drugs and meet with you?
Community service, which he has completed, and fulfill his monetary requirements, which he's also currently in as well.
Which requirements?
The monetary.
Okay. So he is
currently
up to date on everything.
Correct.
Is that correct? Okay. Do you know where Mr. Blewett completed his community service?
He did some donations to some other place. So he completed 150 hours, and the previous officer held the other 150 hours in a day.
Because he had completed those hours.
Yes, within his first year of probation. Yes.
And that was within 3 years of an 8-year term. Is that right?
His first year. It was completed within his first year.
Understood. Where was Mr. Blewett working at the time that you started working with him?
Tesla.
What kind of job did he have?
I'm not sure exactly. That's just with the cars. I know that he had a travel permit to travel, in and out. So I believe he was going to Austin, I think, to work. So we gave him a travel permit, permitted him to travel. I had no issues with him.
Okay. He was working diligently as required. Is that
Yes.
right? Okay. At the time of his February 1st arrest, were you aware that he had another job offer pending?
Yeah, it's from ExxonMobil.
Locally?
Yes.
Okay. Do you know what kind of work that was going to be?
That he could forward me over the documents from the person who offered him the job. He sent it over to me. The issue was that he was on probation. So I told him that early termination was a possibility because he was in compliance. So I believe since he had an 8-year term, it was up 2 years and 8 months, I believe. So he was coming up on that in March. So we were going to look at early terminology so we could get that job.
He was otherwise eligible to at least petition the court for it. Right?
Correct.
When you first discovered, let me ask that a better way. When did you first learn Mr. Blewett was arrested on this February 1st allegation?
I received a flash notice on February the 6th.
The next day.
Yes.
When was your first contact with Mr. Blewett after the February 1st arrest?
So he came to report immediately upon his release, which was on February the 6th.
Did he tell you he got arrested?
Yes.
Okay. Can you tell the court what your reaction to what was to his arrest?
I was shocked because he never gave me any issues during his time on probation that I've been working with him. So I was very shocked.
Have you had further meetings with him since that initial contact?
No, it was just a meeting between me, him, and my supervisor, and since he was out on the accusation, we were just telling him not to contact the victim, and that we did have to file a motion because of the alleged offense, and that a warrant will be coming out. So
Any other things covered in that meeting between you, Mr. Blewett, and your supervisor?
no,
In the time that Mr. Blewett was released on accusation and this new warrant was generated, was he otherwise in compliance for that
Yes.
short, maybe 8 or 10-day period?
yes, sir.
Are you aware, one way or the other, if you don't know, then you don't know, as to whether or not he's had contact with Miss Cantu?
Not that I'm aware of, no.
Are you aware, one way or the other, whether she has attempted to contact him?
No.
If he were, if Mr. Blewett were to make new bonds on each of these cases or otherwise be released, you would expect him to report to you immediately, correct?
That is correct, yes.
Are there any other modifications you would make at this point if he's released?
No, sir.
Do you have any concerns that he would otherwise be compliant under your supervision?
I have any concerns, no. I believe that he can be compliant.
And you don't know anything about this new allegation, is that correct?
I mean, that's someone about it, no, sir.
Have you spoken with the officers involved in the arrest?
No, sir.
Have you spoken with the alleged complaining witness?
No,
in the
sir.
arrest? Have you spoken with the state's attorney, Mr. Coleman, about the new case?
No, sir.
Have you spoken with anybody in the district attorney's office about the new case?
No, sir.
In fact, you, when you first learned about the new arrest allegation, you, I suppose, checked the Odyssey system. Is that correct?
That's correct, yes.
And you learned use, is that correct?
Yes.
Do you know why it was refused?
I am not sure. I received a letter from the district attorney's office saying that the case is going to be refused, so. Further.
If I told you that I've learned that it was at the request of the complaining witness, would that be you wouldn't have any reason to disagree with that, right? Okay. When did you learn that the case had been indicted?
This morning.
Today?
Yes.
Okay. That's what it's doing.
I have no questions for Ms. Stelly.
Thank you, ma'am. Any other witnesses?
Not from us, Jennifer. All
All right, Mr. Coleman.
Your Honor, I saw the reply. I'm sure the court's taking a look at.
I
the
have.
reply. Your Honor, at this time, I would ask or submit to the court for your consideration, a compilation of snippets of a 911 call and 2 body cams. Just to kind of set it up for the court, that 911 call was about 8 minutes long, but I'll cut it down to about 4 minutes. I think all of those 4 minutes are kind of relevant for the judge's consideration this morning. And of the body cams, which were both more than an hour each, I've cut it down to about 2.5 minutes each. Just so you know, the entire clip or video is about a little less than 2 minutes long. But I try to cut it down just to what I think the court should consider or need to consider.
Mr. Kelly.
It's my understanding that the state's attorney doesn't intend to call the alleged complaining witness or any officers involved. So we would object to the admission of whatever this is without it being authenticated.
Judge, the rules of evidence are relaxed in these bond hearings.
They're relaxed. They're not no rules.
Yeah, I don't think there's, I mean, I don't think I can just help me find the spot where I can
Well, the
over
rules of
object.
evidence for these bond hearings, or at a minimum, they are relaxed, is my understanding with the procedural posture for these hearings. I've played these videos for the court in these bond hearings before without a sponsoring witness, judge.
Oh, and if it was without objection, then that's one thing. But if there's an objection, then my thought would be we need to now probably one. I would be willing to say one officer who could set up and look at both. I would be willing to not require, I think, the same amount of information. But I don't think they're so relaxed that I can just watch whatever.
That's fine, Judge. We ask that you recess
Yeah.
at least for a little later in the in the morning, or endeavor
Yeah.
To make my best efforts to get the officer here to sponsor it. I will purport to the court that what you will hear on that 911 video is a 7-year-old daughter of the victim. In
Well,
the
and
case.
911, if you can get one officer here, I think they're, in my opinion, for this type of hearing, they are well enough informed about how that works that I'm not going to require, if you can't get a 911 operator here or somebody from that office quickly, if you can get an officer that can testify that the other officer's body cam, he was also there potentially. I think relaxed to me for this type of hearing would mean that. So I'm willing to give you some leeway on all of that if you can get someone here. So I'll hold it,
Yes, please.
make some calls, see if you can get them here this morning. If not, we are here this afternoon on another hearing. We can work around that so that we can get to it today. What is your schedule like?
I have a hearing in another county, but this is a priority. So.
Okay, well, let's just see where Mr. Coleman can get with getting just one of those officers here. All right, I'll hold it.
Okie dokie, I'll keep an eye, see if that circles back while we're live this morning. Let's stay in the building, go back over to Judge Stevens. Who appears to have nothing to say. So be it. Back to Judge West, then, new contestant.
439, Mr. LaFleur is charged with theft of property, a first-degree felony, November 14th of 2025. And what is the announcement?
So Your Honor, if we could get one more reset, it's indicted as a first degree, stating that the value is 300,000 or more. It appears in the reports, it may be 30,000. So that's a drastic difference of what this could potentially be. So if we could get a reset to make sure that that is accurate, and if so, then obviously that indictment may need to be amended.
And the state would like the opportunity to do a little investigation. Yeah, Ms. Holmes is correct. In the offense report, there's a $30,000 claim. And I don't know if the extra zero was a typo that just fell down the line, but I would like an opportunity to investigate the actual amount of damages.
I'm just looking, what is the current bond set at? And that's probably.
Yes, ma'am. What is your bond?
100,000.
100,000.
Do you have any other holds on you?
Just from Calcasieu.
From Calcasieu Parish, they have a hold on you?
Yes, ma'am.
Okay, so let's just do a normal, I'll do a normal reset. Now, if something happens and you guys figure out that it is 30 and there is an amendment to the indictment, let me know, because I think it would make some sense, depending on other criminal history, maybe not, to at least look at that bond.
Yes, ma'am.
That's set in this case, okay?
Okay.
All right, you can go back with the bailiff. And then you've got Donnie Smith.
If we could hold that, it's gonna be a plea.
Sure, I'll hold that. We'll hold Donnie Smith. I'm gonna hold that one.
Yes, ma'am.
Looks like you've got Darren Campbell ready.
Yes.
Ashley. And Mr. Coleman on Darren Campbell.
I've got it good.
Do you?
Well, it's good for Mr. Coleman to take care of something.
Oh, yes,
Oh,
okay. That's right. All right, sir, are you Darren Campbell?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor. We're going on count one. Is there multiple counts on it?
There are.
It's
Just
count
count.
one.
Okay, let me get that. Please. Getting there. Mr. Campbell, in cause number 25, DCCR 1802, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of assault on hospital personnel on hospital property, October 15th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Yes,
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? Do you fully understand them?
I do.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Campbell is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of assault on a hospital personnel in count 1, a third-degree felony. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed. So you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Do you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts? You can talk with Ms. Holmes. All right. Thank you, sir. You can go back with bailiff. Thank you, Ms. Holmes.
Thank you very much, Your Honor.
Yes, sir. Thank you. Let's see, Ms. Holmes, you have John Dre Willis at the sentencing.
Okay. Was the one with the Louisiana case?
Yeah, Joe, find out
So-
some, let's get him on.
Okay.
Good morning, you're John Dre Willis. And so we were here before for sentencing. Mr. Willis had pled guilty to burglary of a habitation. There was a question about whether or not there was a murder charge pending or coming over in Calcasieu Parish. Charles? Lafayette, sorry. And so what did you guys find out?
Okay. So I spoke with the detective out there. He referred to the prosecutor. Prosecutor said that there is a co-defendant. His case was sent to the grand jury. The grand jury, they don't call it no bill out there. I don't know what they call it. They no billed him on the murder, but they sent in a suggestion for manslaughter. So
On the co-defendant.
On the co-defendant.
Okay.
So the prosecutor told me that it's possible that Mr. Willis' case may go to the grand jury as a manslaughter, but he doesn't know yet. And he said they don't know until Mr. Willis gets to Louisiana. So there hasn't been anything filed on him.
Okay.
Judge, I left a message for same District Attorney Chris Landry on February 24th after we recessed from our last docket. I called back and spoke with his assistant who was going to give him another message. And I made multiple attempts yesterday to reach him and wasn't able to reach anybody at that number where I had previously reached them. So I made every attempt I could to let him know. I filled in his paralegal about the situation we had and said, hey, heads up, if you guys want to hold or you need a 10-day marker or something, it'll be from next Tuesday, meaning today. So
right,
those are the efforts I made. And I would suggest that out of fairness to the defendant, we if the court is inclined, we go along with the original plea of deferred. Sure, if they want to use it later, I'm happy to share my files information with them, but I don't think we should punish him with conviction for something just because that may or may not be out there.
All right, I agree.
And also, Judge, I'm sorry.
Sure.
Just so that the court can recall, this is the one where the complainant went back and forth on wanting to prosecute. She did not. She came to court. She got a little jittery. She changed her mind. She waffled back and forth a few times, which was the reason for it all.
Okay, thank you, Ms. Malvino. And thank you, Ms. Holmes, for making those calls as well. Okay, so what I'll do, Mr. Willis, today is go ahead and go forward with sentencing just the way this was all set up. If something happens when you get over to Lafayette and you're indicted or convicted, obviously we'll know where you are. If you, as soon as you're released, if they get a hold on you and take you straight from here, then when you are released, the first thing you need to do is contact our probation office. So whenever that is, all right. And if for some reason there's a conviction over there or something and you get some type of prison time, then you can write Ms. Holmes or get in touch with her or the court. And there's probably some ways that we can take care of this at the same time so that you're not doing some time and also on probation. Okay. But we'll deal with that when and if it happens. All right, so then in cause number 25, DCCR 1048, I'm going to find that you, and we've already gone over the pre-sentence report and everything. So I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, then this is an excellent opportunity, especially if nothing comes out of whatever happened over in Lafayette, because you do not have a felony conviction on your record. And if you successfully complete this probation, at the end, the case is dismissed. You'll never have the felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be found guilty. So you would become a convicted felon and you could be sent to prison for anywhere in that range of punishment, which is between 2 years and up to 20 years in prison. Do you understand? And I'm assuming there is a no contact.
Richard.
What's the name?
Colette Richard.
Colette Richard. And so you're not to have any contact or communication with Colette Richard. And I understand that she's going back and forth and y'all have gone back and forth. But unless you have my permission, which could happen if you get out and you're on probation and you're doing well, and she probably takes an options class or something like that. If y'all are planning some type of relationship, you're not, so we don't have to talk about that. Then don't contact or communicate her. If she tries to contact or communicate with you, don't reply, okay? Because she won't go to prison, you will, right? All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. All right, good luck to you, sir. I think, is that all you've got?
Mr. Smith, Donnie Smith.
Okay.
Did this come through?
All right, let's try one more time with Judge Stevens and see if we can actually hear something this time. Oh my goodness. All right, I'm giving up on him for today. That's just the way that is. Let's do this then. Let's try another one who likes to mute this morning. Let's try Judge Mom.
From Mr. Ford.
Thank you. Good morning, Mr. Ford. Your name for the record, please.
William Marshall Ford.
Counsel as to the arraignment.
Yes, Your Honor. At this time, we are prepared to waive a formal reading. My client stands mute.
The court will waive the formal reading. You have the right to have an attorney. If you are unable to afford an attorney, you may have one appointed to represent you. And in fact, you've had an opportunity to speak to an attorney today. Is that correct, sir?
Yes, sir. I mean, ma'am.
The court has also signed the petition in order for appointing an attorney for felony matters. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, ma'am.
The court has entering a plea of not guilty on your behalf, scheduling this matter for a probable cause conference on March 12th 9:45 a.m. All right, council, as to bond.
Yes, Your Honor, I would like you to know that Mr. Ford currently is residing in Wyandotte. He works locally at Britta's Biddle Avenue Florist. He's been there for roughly 3 years. He's not currently on probation or parole. He has no other pending matters out of any other jurisdiction that we're aware of. And after speaking with Mr. Ford at length this morning, he did assure me he would be appearing at all future court dates and understands the importance of doing so. I would just ask that all that be taken into account when assessing a bond.
All right, and so Mr. Ford, how long have you been working at Brenda's Flowers?
I've been working there for approximately 3 years.
And what do you do there, sir?
Well, a little bit of everything. I move heavy stuff for the girls. I deliver flowers.
And
Take
do you
out the
live
trash.
above where you work, sir?
Yes, ma'am, I do.
Okay, well, I was looking at the address and that's what it seemed to be. All right, and you're not out on bond in any other jurisdiction, sir?
Ma'am,
And when were you released from prison on your matter that you were sentenced 25 to 50 years on?
about a little over 4 years ago.
And I'm sorry, do you know Mr. Demick?
No, I do not.
Have you ever failed to appear in court for any reason, sir?
When I was younger, yes, ma'am.
Have you since resolved those issues?
Yes, I have, ma'am.
And who resides with you, sir, at your home?
My employer's daughter. We live together.
Are the two of you in a dating relationship?
Yes, ma'am, we are.
Okay, I mean, usually somebody would say my girlfriend, but my employer's daughter. Okay. And how long have you been dating your employer's daughter?
A little over 3 years.
All right, and sir, when you were released from prison, were you placed on parole or did you finish your sentence?
And I was placed on a parole and then I finished my parole. I was
Okay,
living
when-
in Southgate and I finished my
sorry?
parole down here.
What about Southgate?
I said I was living in Southgate while I was on parole and I finished my parole down here. I started my parole off over in South Lyon at my mother's address.
Okay, and so when were you discharged from parole, sir?
Wow, what was that? I don't know the exact date, ma'am.
Well, I'm just
But it
trying to
was,
do the math.
I
How
did
long were you on parole?
a year.
Okay, so then you,
Yeah.
all right, so you've been off parole for 3 years then, since you've been living in Wyandotte, correct?
Right.
Okay. All right, Detective, would you like to address bond?
Your Honor, taking into consideration the nature of the dangerous or the severity of this offense, and the defendant's criminal history and not having any knowledge of who the victim was or not knowing who the victim was or having any previous altercations with him, I would recommend $100,000 10%, Your Honor, and in addition to a GPS tether to ensure the defendant's next court appearance, Your Honor.
And it's expensive, honey.
Sir, you're facing a habitual offender fourth offense, and you are facing up to life in prison, sir, if convicted of the first count, which is a 5-year felony. And because that one's 5 years or more, then you're facing life in prison. And not only that, sir, but the court has serious concerns for the safety of the public. Because if the allegations are true and the victim in this matter simply went to check on you to see if you're okay, and he himself ended up in the hospital as a result of your actions, then that's extremely concerning to the safety of the community. The The court will note after review of Mr. Ford's criminal history, two of which are significant and of an assaultive nature, one of which landed Mr. Ford in prison for 25 years. The court does find that bond would be appropriate, the amount of $250,000, 10% bond.
Thank you.
That's based on the reasons that I just stated on the record for just a moment ago, specifically to protect the victim in this matter and the community at large from Mr. Ford's actions and behavior. In the event bond is posted, sir, you're not to return to Captain's or any other bars. You also, sir, are not to have any contact with Mr. Demick. That's whether you post bond or not. That's phone contact, text message, email, social media, third party, anything of the like. You're not to possess or consume any alcohol or drugs unless prescribed. You are not to possess or have access to any firearms or weapons. Do you have any of those?
No, ma'am.
You are not to be released without GPS and alcohol tethered from the Wayne County Jail. Any questions?
No, thank you, Your Honor. All set. Thank you.
Thank you. Have a good day.
All right. So, how much
Again, Kendall Bryant? Is that? Let's go off the record for a moment. Do you have to speak to Kendall Bryant?
Please.
Okay, all right, so we're gonna put you, two of you back in this breakout room. Okay.
Thank you.
That one, no, that one will keep up.
That's the one.
Yeah. Okay. All right, Mr. Borkin, are you ready to proceed?
Yes, we are ready.
Okay. All right, so do you want me to do these or do you want to keep going? for these here? Okay. Not going to object to that. Okay, so we are on the record in the matter of Green Trees Apartments versus Erica Johnson, 2600101. And counsel, your appearance, please.
Christopher Borkin, PH 6265 for the plaintiff.
All right, Ms. Johnson, your name for the record, please.
Erica Johnson.
All right, and so counsel, you did have an opportunity to speak to Ms. Johnson in a breakout room, correct?
Yes, I did, Your Honor. We reached an agreement in the form of a consent judgment.
Okay, and that consent judgment is what, counsel?
We've agreed rent to retain is $4,228. Court costs are $180, totaling $4,408. Ms. Johnson does say, though, in further orders, defendant states she paid $1,000 on March 2nd, yesterday. Plaintiff shall credit upon receipt. And the writ date in 4A, Your Honor, would be March 13th that she's agreed to pay back the remaining balance. Additionally, she gave me permission to sign on her behalf, and I did explain her rights under MCR 4.201J.
Okay, and so ma'am, you heard the terms of that judgment, correct?
Correct.
And you understand that Mr. Borkin represents the interest of your landlord and not your interest, correct?
Correct.
And you've received your advice of rights in your packet of information, is that correct?
Yes, ma'am.
Ma'am, I need you to turn on your camera.
Okay.
Okay, I can only see your forehead, ma'am.
Oh, sorry.
All right, thank you. Okay, and you've had an opportunity to review those rights, correct?
Yes.
And you understand that by entering into this agreement, that you'll be waiving some of those rights.
Yes.
specifically your attorney rights and rental assistance rights. Do you understand that?
Yes, ma'am.
Do you have any questions regarding those rights?
No.
You also understand, ma'am, your rights under the court rule is explained to you by Mr. Borkin, correct?
Yes.
Do you have any questions regarding that?
No, ma'am.
All right, the court does find that the waiver of rights is valid. The terms of the judgment are reasonable and fair. The court finds the plaintiff is entitled to, by consent, plaintiff is entitled to recover possession of the property. The amount now due and owing for unpaid rent and other costs is $4,408. Defendant will receive a credit of $1,000 from the payment she made on March 2nd upon receipt from your landlord. And if the amount is not paid, the defendant does not live out on or before March 13th, plaintiff can apply for an order evicting the defendant. Additional money may be owed if damage to property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant, and no money judgment will enter at this time. Any questions regarding those terms?
No.
All right. And ma'am, do you have any objection to this court indicating via Zoom on your signature line?
No.
I'm sorry, what's that? I couldn't hear that.
No. Can you hear me?
Yes, no, I can hear that time.
Okay.
All right, the court has signed the document, this judgment, and you will receive a copy of this shortly.
Okay. Thank you.
Thank you. Have a good day.
You too.
Thank you.
All right, friends, let's go back to Judge West. Looks like she has a new contestant.
Let's see, this is Miss French on William Jones. Good morning, sir. Are you William Leroy Jones? Mr. Jones, in cause number 25 DCCR 1627, you're charged with the state jail felony offense of theft with previous theft convictions from August 3rd of 2025. The indictment alleges you were previously convicted of theft June 1st of 2023 in 2 cases. After that was final, November 16th of 2023. And then after that, August 6th of 2024, and then 2 cases on August 15th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand? And then in cause number 25 DCCR 1628, you're also charged with theft of property with previous convictions. Offense date in this case is from August 2nd of 2025. Those same prior convictions are applicable and listed. Same punishment range if you're found guilty. Do you understand? Yes, ma'am. And cause number 25 DCCR 1629, also charged with theft of property with previous convictions from August 9th of 2025. Same prior offenses, convictions are listed. Again, means if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years. Do you understand? Yes, ma'am. And then finally, in cause number 25 DCCR 1630, you're also charged with theft of property with previous convictions. This is from August 15th of 2025. Again, it lists the same prior convictions, makes it the same punishment range between 6 months and up to 2 years. Do you understand? Excuse me. In all of those cases, I have here on the tablet some documents called plea bargain rejections that you signed with Mr. Lewis. This shows that the district attorney's office has made offers if you wanted to enter pleas of guilty. And it looks like for 20 months in the state jail, and that would run concurrently in all the cases.
Yes, ma'am.
You have every right to reject that offer and have all 4 of your cases tried to a jury. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am, I do.
And do you want to reject those offers and have all of your cases set for trial?
Yes, ma'am, I do.
All right, we'll get that done. Ms. French, is there any reason to believe that that offer would be reduced?
Mr. Lewis has spoken with me this morning about a possible issue for me to consider. I don't know that that's going to move the needle for me, but it's a possibility.
So what I'll do then, I would like, how long will it take you to kind of look at that? And I don't want to put it on the trial docket. If there's a potential, we could do it as soon as that's over. So let's reset it for 2 weeks.
2 weeks.
Okay.
If there's some change in offer, then I've already, if you want to, okay, just leave them there. I've sent them to you and we can always write on it if it changes to a different offer. Otherwise, we'll go through that process of setting it for trial on that day. All right, so we'll reset it for 2 weeks. Thank you.
Into the child, go speak to the child.
Okay, thank you.
Okie dokie, friends. TCF Live on a Tuesday. Good to have you all here. We are 2 hours and 20 minutes into the show already. I do not understand how time flies so quickly. Probably because this is fun. Fun things pass quickly. Let's go Louisiana, checking on the board.
Ledoux and Chuck Tillis, and we're here to talk about Mr. Jeremy Pollock. Mr. Pollock is in Dixon Correctional Center. Would the staff there, Warden, would y'all introduce yourself, please?
Yes, sir. Good morning, Dusty Bickle, Ward. Donald Cavalier, classification.
Ashley Bradley, records.
Alvin King, reentry. Curtis Thurman, mental health. That's it, sir.
Okay, good. Y'all got a big roll call there. Okay, Mr. Pollock, how are you doing today?
Doing fine, sir. How are you?
I'm doing just good, doing good. Your case has been assigned to Miss Cherry Ledoux, who is on my right. And we've all read your case and all of that, but she is the lead interrogator, investigator. And so she's gonna be asking you some questions. And then we're gonna have a chance to ask some questions. And so we'll go ahead and turn it over to her and let her talk to you.
Yes, sir. Thank you.
Pollock. Mr. Pollock, for the record, I would state that you're a third-class offender. You were sentenced to a 17-year sentence for theft and legal possession of stolen items. You have a parole eligibility date of 9/11/2026, good time date of 5/29/2027, full term date of 2039. You do have people here in support of you, your mother, brother, and the Louisiana Parole Project. Before I would ask you any questions, I would like to get the warden, if you will, Mr. Bickham, whatever you would like to add to this.
Yes, ma'am.
You probably know him better than else right now.
Yes, ma'am. Thank you. And good morning to y'all. He's a trustee here, which, you know, one of our top level guys. He's a level 1 trustee. He works down there actually at headquarters on Mr. Jarvis's crew doing some work down there. So we trust him enough to go down. He's done a tremendous amount of classes. I think he's been over a little 4 years roughly. He's been locked up. He has had no write-ups at all, which is impressive. And besides the classes, some of the classes he's been through, Malachi Dads and different ones like that from the STAR program. I will say he attends church regularly and he does represent the faith well around here. So he does that. So that's pretty much it. He's a pretty good guy.
Could classification tell me if he's completed pre-release?
I think completed. He's currently enrolled.
Currently enrolled. Okay, great. That's one of the questions I had. Mr. Pollock, you were on probation when this occurred. Is that correct? And you were revoked?
Yes, ma'am.
Okay. Well, you do have your mother. I'd like for Miss Cheryl Pollock to speak first. Miss Pollock, you can just tell the panel what you would like us to know.
Yes, ma'am. My name is Cheryl Pollock. I am Jeremy Bryce Pollock's mother. I'm here today to speak on behalf of a favorable outcome for Jeremy in his parole hearing. Since birth of his oldest son, Waylon Bryce Pollock, Jeremy has displayed excellent parenting skills. During his incarceration, he has spoken to one or both of his sons almost every day on the phone. Since both sons are under my guardianship, Jeremy has been able to maintain a close relationship with them. He's been able to keep up with their academics and sport events for both boys. During Jeremy's incarceration, I have observed continual personal growth. He has learned numerous skills at his assigned jobs. He has earned money with his hobby crafts and has purchased numerous tools to use in the hobby shop. These skills and tools will enable him to do maintenance and remodeling on the 3 houses that I currently own. I also have seen emotional and spiritual growth as he has participated in numerous good time classes as well as available church services at his facility. I truly believe my son has worked hard toward his rehabilitation. He has passed all of the random drug tests that have been given to him, as well as maintained a spotless record with no write-ups or infractions during his time of incarceration. Jeremy's drug addiction caused him to commit crimes that I believe he would not have committed had he been sober. I believe that he has sincerely worked on his addiction and will continue to work on personal growth in order to maintain a profitable and sober lifestyle. Jeremy has convinced me of his remorse and has apologized numerous times for his guilt in the charges that were brought against him, which led to his incarceration. I am willing to allow him to reside in my home with his 2 children upon his release. I am looking forward to reuniting our family and allowing him to help me finish raising his sons to be strong, law-abiding young men. Thank you for your time.
Thank you. Your support is critical. We also have Ben Pollock, your brother and the victim in the crime. Mr. Pollock, if you would like to speak.
Yes, good morning, members of the board, and thank you for this opportunity to speak this morning. My name is Benjamin Pollock, and I'm Jeremy's brother, and I was also the victim in the case that led to his probation and parole being revoked. In August of 2020, my ATV was taken from storage by Jeremy, and I first gave him the opportunity to return it without formal charges being filed. And when that did not happen, I reported the matter to law enforcement in Vernon Parish. And at that time, I made it clear to them, as well as the district attorney's office, that I was not acting out of a personal vendetta, that my concern was accountability. And I believe then, and I believe today, that if a person will take property from family and justify it by saying I needed it, that they will take property from anyone. And I don't believe that respect begins and ends in the family, but I believe it begins there, is taught there, and is meant to be lived outwardly in society. And so that kind of behavior cannot be excused. It must be corrected. However, when the charge was filed, I asked only for the minimum necessary to obtain a warrant and recover my property. And the decision to pursue felony charges was made by the district attorney and sheriff's office due to post-hurricane circumstances at that time. And I respected their judgment then, and I respect the justice system now. During the pretrial discovery phase, I was asked by the district attorney's office for any recommendations that I might have regarding potential sentencing. And I said that my goal was accountability and deterrence, and that I trusted the justice system. And when probation was granted, I did not resist that or resent it. My position has remained consistent over the years, that actions have consequences and lawful living is not optional. However, accountability and restoration are not opposites. Accountability is the pathway to restoration. purpose of consequences is correction. And I pray that the consequences have been felt and understood. And if Jeremy's institutional record reflects compliance, and if he's completed required programs and demonstrated lawful behavior, and it sounds to me like he has, then I have no personal opposition whatsoever to his release. My brother is nearing 40 years of age, and at some point, a man must either remain defined by his worst decisions, or demonstrate that he has learned from them. And my hope is that Jeremy has decided to put his past far behind him and live that decision out in practical, everyday life, if given the opportunity to do so. I'm not here today to minimize what happened. I'm here to say that I do believe accountability has occurred and time has been served. And as a minister of the gospel, I do believe that by the grace of God, it's possible for a person to move away from their past and become a productive member of society. And my hope and prayer is that I will see my brother living in freedom again and living responsibly very soon. And thank you again for your time, and thank you for the work that you do.
Thank you. We also have Channing Blake with the Louisiana Parole Project.
Good morning to this honorable board. Channing Blake with Louisiana Parole Project, appearing on behalf of Mr. Jeremy Pollock. Due to his faith-based participation, the classes he's taken, he's been write-up free. Him being a trustee and many other factors, he's been accepted into our program. If this board deems it necessary to grant him parole, we're committed to his reintegration into society. He'll participate in our intensive reentry programming and services. He'll be given transitional housing. He will also be assigned a reentry specialist and a mentor that'll guide him through the reentry process. So today we ask this honorable board to give him a favorable recommendation. Thank you.
Thank you. Mr. Pollock.
Yes, ma'am.
420 days. Let me tell you what I noticed is the 4 different types of substance abuse treatment programs that you've taken, which you recognize you had a drug problem.
Yes, ma'am.
What are you going to do? You are granted parole to maintain your sobriety and stay away from illegal drugs. And by the way, marijuana is an illegal drug. Okay. So I just want to make sure you know that.
Yes, ma'am. Absolutely. Marijuana is an illegal drug. I agree with that wholeheartedly. At my time at DCI, in which I believe that the Lord charted my path here, because this place at DCI offers everything that a man needs for his rehabilitation and recovery process. And I'm sorry I'm having such a hard time right now, but with that being said, my classes that I've taken here, that I've never had an opportunity to learn the valuable information, not to take away from any faith in God, but the programs and rehabilitations that I've been to have all been faith-based. And but here, through the classes that Department of Corrections have instilled in prisons to offer, as far as NA and AA meetings and Malachi Dads and substance abuse and the STAR program, I have learned the proper tools that I need. And to answer your question, I have learned 3 different attitudes of awareness, staying surrendered to my higher power, which is my Lord and Savior, Jesus Christ. And I've learned an attitude of growth. And those would be 3 attitudes that I have to keep for the remainder of my life. I've also learned that without drugs,
it gives me an opportunity to function as a useful human being. And I'm given that opportunity every day as a trustee to come down to Baton Rouge and work at DOC headquarters and do the things that's asked of me and complete the construction projects that's asked for me to do. And that gives me such a sense of belonging in this world. And I believe that a man can only have that sense of belonging if he stays living a life full of sobriety. I can also tell you that I've learned through my NA and AA meetings that any clean addict is a miracle. And that's, as of today, I've been clean for 44 months and 17 days. And I can tell you that my commitment to staying clean and living sober will not change in the event that I'm granted parole and I'm allowed to be a productive member of society. And in this 44 months and 17 days, I've learned to know what true happiness and joy and freedom is. That's what the classes that I have involved myself with and taken voluntarily. And I can just say that all of this is in part to the Lord, because as I attend the faith-based programs that they have here, and I don't know if I should say this or not, but the warden here has allowed the Spirit of God to move at this prison. It has helped me tremendously. And when I read my Bible, I see in the King James Version, it says in John chapter 8 and 36, if the Son therefore shall make you free, then you shall be free indeed. And I truly believe that through God being the source of giving the DOC department and helping them implement classes and programs and meetings for men to take that are in prison, I believe that if a man truly prepares himself and as far as preparation is concerned, then he'll be able to deal with different feelings of things that are of nature. So I say that as a man sitting here today in front of you, I have truly prepared myself through my classes and programs and meetings within and my religious and faith-based programs. So to answer your question, ma'am, I believe that I'm ready, and I believe that I've done the things and acquired the things that are going to allow me to be a productive member of society again.
Well spoken. I don't have any other questions. Do either of my colleagues have any questions?
I don't have any questions. No questions.
I'm prepared to vote. And I will say I appreciate your heartfelt remorse and plans for the future. I base my decision on evidence, and the evidence indicates that you pose no significant public safety risk. You have no opposition and have done your rehabilitative work, and you have excellent conduct and plans for reentry. So based on that evidence, my vote is to grant parole today.
I concur with Ms. Ledoux. Okay, and I concur also. So as of 9:23 this morning, your parole has been granted. Thank you.
And there we go. Approved. Let's go back to Texas, Judge West.
2025. And how do you plead to that charge? Guilty. Are you pleading freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1 Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any type of, any right to appeal?
Yes, ma'am.
And so I see it's just marked off community supervision, but nothing
So
else.
we're unagreed as to the type. The state is recommending straight probation. We're recommending deferred.
And leaving the type and the amount of time
Yes.
up to the, so I want to make sure you understand that the agreement is that you get probation. The type of probation, whether it's straight or deferred, will be up to me at sentencing, and also the length of time that you're on probation, any conditions, and any fine in addition to that. Do you understand?
Yes, ma'am.
And you have an absolute right to have a jury come in and determine if you're guilty or not, and you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you have to do?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Ms. Malfino, what is the state's position with regard to a bond reduction based on that plea?
Judge, in reviewing Mr. Coleman's notes in this case, it doesn't appear that this young defendant has any substantial criminal history, just so the court is aware of pending UCW and evading also arose out of this incident. And so it's obviously concerning to the state that a weapon was involved, but I've heard of what you think is appropriate, unless Mr. Coleman has additional to add.
Okay, that's an answer. Thank you.
Thank you. All right, Mr. Smith, what I'm going to do based on the nature of your plea agreement is reduce your bond in your case to $2,000. If you make that bond, there's a couple of very important things that are going to go along with it. One, the very first thing you do is go straight to the probation department so they can start that process to get that report done for me. If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be much worse. Do you understand?
Yes, ma'am.
Also, if you make that bond and you are arrested for anything between now and when you come back, you obviously run the risk of me not accepting the agreement. You understand that as well?
Yes, ma'am.
In addition, I'm going to order as a condition of that bond, you are to have absolutely no possession of any firearm. Okay. That means you can't be in a car with someone else that has a gun. You cannot be in a home where there are guns. You cannot be around any guns until further sentencing. We'll figure that out depending on what's going on with that misdemeanor case. Do you understand? Any other conditions that?
No, Joe.
All right, then we will see you at sentencing. You can go back with the bailiff.
Alrighty, let's head back to the board. New contestant, Louisiana.
To my right is Jerry Ledoux. We're here to talk to Mr. James Mitchell, who is at Caddo Correctional Center. Mr. Mitchell, is that you I'm looking at on TV?
Yes, sir.
Okay. What is your DLC number?
411770.
Okay, and you got a form in front of you, I'm sure, but it allows you to choose whether you have an attorney or not. And I see you do have an attorney. We have Mr. Eric Johnson, who is here all the way from Caddo Parish or Bossier Parish, Webster Parish, and anyway up north, and he is here to represent you. So having said that, before we get into the case is Ms. Jerry Ledoux's, well, I'll tell you what, I'll just turn it straight over to her and let her talk to Mr. Johnson and see where we go from there.
Okay, Mr. Mitchell, you already settled the issue of having an attorney, so I don't need to go there. You've been accused of violating two conditions of your parole. Condition number 4 says that on or about 9/19/2023, you committed the offense of simple burglary, 3 counts, and was arrested by Caddo Parish Sheriff's Office. These charges are still pending, and arguments and hearing is set for April 6, 2026. You are allowed to enter a plea of guilty with a statement, or not guilty, and you may defer to your attorney for assistance in making that plea.
Okay. Mr. Dude, we would asked to enter not guilty plea and spoke with Mr. Abbott. We may have a resolution to Mr. Mitchell's charges in CADO, which I think is the main basis of the revocation when he goes back to court on April 6th. If I could request a continuance some after April 6th, we may have an easier decision, you know.
So, Mr. Johnson, are you saying that you believe these charges will be dismissed?
But I've spoken with the assistant district attorney about is a dismissal of the charges if a sum of restitution is paid. That's correct.
Okay, because, you know, we don't look at necessarily, we look at violation of parole conditions. So if he was involved in illegal. Okay, so you're pleading not guilty.
Yes, ma'am.
And we also have violation number 10 in that he is in arrears of $590 in supervision fees. How would you plead to that?
Guilty.
The review of the file, for me, it was evident that there was a crime and that you did commit from the evidence, a burglary. Tell me about your conduct on parole other than that incident. Do you have any other problems?
No, ma'am.
Were you working?
Yes, ma'am.
Okay. So, if you're working, tell me about the lifestyle that would put you in a position to be stealing things, even though you're working. What's going on?
I took on too many responsibilities and got overwhelmed.
So you were actually paroled. You were a parole case.
Yes, ma'am.
Gift of parole. Because you have a full term date of 5/2/54. You're a third class offender.
Yes, ma'am.
The people want a second chance, and I get that. You were given the gift of parole.
Yes, ma'am.
So were you having any kind of substance abuse issues?
Toward the end.
So what precipitated this? What was the trigger that got you where you are? Be honest, I need to know so I can determine what to do.
I got overwhelmed with all the responsibilities I took on.
Tell me about the responsibilities.
Like I bought me I worked on getting me a house, and I had so many bills and so many things that I couldn't, I had a family to take care of, and we were just lose everything. And
Are you married?
no, ma'am.
How many children do you have?
I have one. I have a daughter and a grandchild.
I have pictures and everything. Crying. Mr. Johnson, do you have any statements you would like to make on behalf of your client?
I think what Mr. Mitchell said sums up why the conduct occurred, that he overloaded himself with financial obligations that he could take care of through his job, and that led to, I think, relapsing into substance abuse, and that's where the acts occurred.
Okay. So, Mr. Mitchell, you were on drugs.
Yes, ma'am.
You have a drug problem.
Yes, ma'am.
Have you had, how many years did you spend, before you were paroled, how many years were you incarcerated?
12 years.
Did you have any substance abuse treatment while you were incarcerated?
Yes, ma'am.
And what was that? What kind of treatment?
AANA and Celebrate Recovery.
Okay. Panel, I would defer to you if you have any other questions.
I have no questions. Okay, this is and what offender, I was looking for your offender class. What offender
The
class?
third class.
Third class offender. Mr. Mitchell, you, I know you got a very capable attorney here, but sometimes it gets to the point of no matter what the representation is and all that, but you just a slow learner.
Yes,
I mean, how much more can you expect us being the taxpayers and the citizens of Louisiana to put up with from you? That's what bothers me, whether you make restitution or not, whether they drop the charges or not. The point remains, it's pretty evident that you're involved in criminal conduct again. And that's what bothers me. Why? Why are you such a slow learner?
I don't even have an answer for that, to be honest. No, you're right. You're absolutely right. No, it's all about who you surround yourself with. And I just surrounded myself with the wrong people. And
Well, some of them here last week and they said you were the wrong person. You know what I mean?
that's my,
Yeah, okay. Not just about other people.
Yeah, it seemed like, from what was in the record here as far as the Facebook posts and things like that, that y'all were all pretty wrong. Y'all like bad chemistry.
Yes, sir.
Y'all bad for each other. Not just, you can't blame it on them.
Yes, sir.
Okay, I think if that's all, are you prepared to vote for, and of course, we have the choice of a continuance, do not revoke or revoke in lieu of.
I'd ask to go into executive session.
Okay,
A second.
we've got a motion and a second to go into executive session for just a minute to talk about some procedural matters. The time is 9:36 in the morning. We'll be off air for just a few minutes and we'll be back in just a moment.
I gotta be honest. Why an executive session here? Forgive me, be preachy for just a moment. Lord, deliver me people who take accountability for their actions. Once again, somebody, hanging around the wrong crowd. Well, that's on you, dude. You know, you choose the people you hang out with. Nobody forces you to. Nobody forces you to do anything unless you're in prison, in which case you're going to be forced to do some things. But, you know, you have agency over your life. Everybody does. And nobody seems to want to accept that. And yes, it's a responsibility. You have to be responsible for yourself rather than offloading it onto somebody else. But, you know, I suppose there's a reason why these people are where they are. It's because they haven't taken agency over their lives. They haven't worked to fix themselves. I'm just saying, it drives me nuts. You guys know that, so this is nothing new, but I like it when people get up and say, you know what, this one was on me. You know, I did X, Y, and Z wrong. I regret it for these reasons. And yeah, I needed to do better and I didn't. I cheer for those people. I really do. But this sort of person, not as much. All right, we're in the way back machine. Let me push this forward here. All right.
Okay, the time is 9:40 in the morning. We've been in executive session. Could I have a motion and a second to come out of executive session? Go into regular session. Got a motion and a second, and there is no objection. So at 9:40, we are out of executive session into regular session and still considering the case on James Mitchell on a revocation hearing. Okay, this case has been assigned to Ms. Ledoux. I think we've had our questions. And we discussed some possibilities back on procedural matters, but I think we're ready to vote now.
Mr. Mitchell, the role of the Committee on Parole and Revocation is to determine if there is evidence that you have violated your conditions of parole and to make decisions based on that information. And the evidence clearly shows me that you have violated your parole and that you should be revoked today. So my vote today is for revocation, based on your admittance and the evidence that I see.
Okay, Mr. Phillips?
My vote also is to revoke for rule number 4 and 10.
Okay, and Mr. Mitchell, I'm like my panel. I feel like you've been given so many bites at the apple. The only thing left is the core. And my vote also is to revoke you, violation of condition 4 and 10. And therefore, as of this morning at 9:42, your parole has been revoked.
Yes, sir.
Well, as he just said, so many bites at the apple, the only thing left is the core. I suppose the good news is once you get to the core, you are left with seeds. So perhaps they can plant those seeds and regrow this person's life. All right, Michigan, Judge Mom.
And Mr. Elliott, your name for the record, please. Okay, thank you. Just please make sure you keep your hands out of your pockets. And counsel, today, and I don't recall if you were the attorney of record when we were here last.
I was not.
You were not, okay. And so the reason that I scheduled this hearing, counsel, is because I had some concerns over the process serving, which is why we requested the process server to be present. Because there was a default that was issued against Mr. Elliott. And in reviewing the proof of service, let me just get to that. It is not this defendant. And so that raises some concern for this court. The proof of service that I have, and I have it pulled up right here, is that the documents were personally served. Brown-haired white male, 45 to 55 years of age, 5'8" to 5'10", weighing 160 to 180 pounds with glasses. Okay. This is not that defendant. And when the court inquired of Mr. Elliott under oath, he does not, there's not another James Elliott that resides at the property. Is that correct?
Correct.
And that the only other male person in the home is his son, who obviously would look 45 to 55 years old. And the court also looked at Mr. Elliott's identification, his driver's license. The court even went so far as to ask how long has he been bald, because I thought maybe he possibly could have shaved his head, right? And he says for at least 20 years. Is that correct also? Now, this is all going from memory on that because I didn't write that information down. And he also stated it's been a while since he's been anywhere between 160 to 180 pounds, right? Would that be accurate? Okay. So counsel, the court had your process server come forward because that is not who this person is. And it's saying that she personally served the defendant. And then the court had relied upon that service and entered a default judgment against the person that was actually never served. So, ma'am, if you can please step forward. Yes. I'm going to have you please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
Okay. And if you can please state and spell your first and last names for the record.
Alicia Sturgis, ALY, S as in Sam, IA. Sturgis is STURG as in George, ES.
Okay, thank you. And so, ma'am, how long have you been doing process serving?
Since about August or September.
Of 2025?
Yes.
Okay. So you just heard what I stated occurred and that occurred on Tuesday, November 4th at 3:17 PM.
Yes.
So what happened? Because who you served is not this individual.
Do you want me to go through my process?
That's a start, yes.
So from what I've been trained on, I go to the door, I verify the address, I knock on the door, the person came to the door, I stated the name, they reached out and said yes, took the paperwork, went back in the house.
You don't confirm by identification? How do you confirm that it's the person?
I state their name and they confirm.
Okay, so if somebody
Work through a gig app, so
a what app?
a gig app, ABC Legal.
Okay,
So they have like things in there that I have to like press, and they don't require me to ask for an identification.
have you reviewed the court rules, ma'am, that regarding the service of process?
I reviewed the paperwork they gave me.
Okay, ma'am, let me just be very clear, all right? When you are serving legal documents and then you're signing an affidavit, you are telling this court and any court that what you're submitting is true. It's an affidavit. And so if you're not submitting truthful paperwork to the court, that's very problematic. It would strongly be worth your while to review the court rules as to what your legal obligations and responsibilities are, not just a summary of a training that you've received from whomever you received it from. Because there are court rules and even statutes that govern the service of legal documents. Because what happened in this case is that the person you served was not the defendant. And then a default judgment was entered because this defendant did not receive the paperwork.
Okay.
And so, unfortunately, this is more common than it should be. I'm not saying with you specifically, but in general, this is more common than it should be. And what happens then is an individual has a default judgment entered against them and they know nothing about it. They don't know anything about it until their wages are garnished, or their vehicle's repossessed, or their tax return is garnished. And then that's when they find out about it. Those could have serious, serious financial consequences and repercussions.
Understood. I signed up with the app. They sent me the paperwork. That was the training. That was to the extent of what I've had. I didn't have like a formal like process serving trainer person to take me out. I went by what their rules were.
Who's there?
ABC Legal, the app that I work for.
So it's an app. ABC Legal is an app.
They're a process serving company all across the country. It is.
Yes. So you get the serve, they give you like the notes and stuff within the serve. You go and verify, you get training, and that's to the extent of like my knowledge. I didn't know that there was a step of like a formal ID that I needed, because that's not what was presented and stated that was needed.
Okay. And I can appreciate, ma'am, that you're, venturing down this path of employment and profession.
Yeah, I'm trying to learn.
Right.
I signed up, I saw some TikTok videos to try to get a better understanding. I read through all of their training, and so
okay,
now I'm here.
So here's what you should probably look into.
Okay.
You should probably look into the State Bar of Michigan, whether or not they offer, whether they offer training for process serving.
Mm-hmm.
And I don't know what ABC Legal's training repertoire consists of. I don't know if they go through how significant a process server role is in a legal proceeding. because all parties, whether it's the plaintiff or the defendant who's ever doing the serving, and the court must rely on that process server.
Understood.
That is telling the truth, right? I'm not suggesting, ma'am, that you deliberately or that you falsified anything, or you did anything deliberately, right? I do believe that you did what you were trained to do with limited information. It's always a really good idea to ask for the individual to show their ID.
Okay.
For a number of reasons, because in some cultures, you have parents or grandparents of an individual that all have the same name,
Yeah.
and you don't know if it's that person.
Very true. So that's not detailed when I get the serves either.
Correct.
So,
Correct. Now, I do commend you on your level of detail in who you personally served, right? I don't know who that person is. You live at 856, is that your address?
Yes, ma'am.
Right. I don't know if you had somebody visiting. I don't know if you had somebody dog sitting. I don't know. So, but in any event, I think we're all very clear that that the person you served was not this person. Is that accurate? I know that you serve a lot of people. So,
yeah, like we're going to go off the description. Yeah.
okay.
It was not intended to be fraud. Like I said, my process is to literally go there, I identify your name, and once I verify your address, and that's.
No, man, I believe you. I believe that you did not intend to defraud the court or mislead anybody. I 100% believe you. I just want you to be clear on that.
Okay.
I'm just trying to utilize this.
As a teaching moment. Yeah.
Correct. Right. So I would check with State Bar of Michigan if they offer any training options. State Court Administrative Office, you can check with that group to see if they offer any training opportunities for process servers. And then you should review the Michigan court rules regarding service of process and process servers, as well as any Michigan statutes that would require that would govern that as well.
And Michigan statutes. Thank you.
Okay.
Yeah.
And you may even want to check to see if ABC legal process serving gives you state-specific training. Because if there is, Mr. Fay indicated, they are nationwide, every state has different laws and requirements. So I don't know if their training is state-specific, so you may want to check into that also.
Will do.
Okay. All right. Thank you very much for showing up. Mr. Elliott, is there anything that you'd like to say?
No, ma'am.
Okay. Mr. Fay, anything that you'd like to say?
No, you're.
Okay. All right. As far as Ms. Sturgis, your presence is complete. What I needed you here for is complete. Counsel, have you and Mr. Elliott, has there been a resolution with anything?
I haven't spoken to anybody.
Oh, okay. Well,
When I do call, they won't speak to me. They verify who I am and hang up
okay.
because they won't allow me to record the call.
Because they what?
They will not allow me to record the call from my end. They record it, but I'm not allowed to.
Oh.
Tell me that their client doesn't allow me to record and they hang up.
Okay. Well, okay. All right, Ms. Sturgis, you're all set. Thank you.
Thanks.
Okay, so did you receive a copy of the summons and complaint emailed to you
Yes, I did.
and mailed to you?
Yes.
Okay, so did you file a response?
No, I did not.
Well,
What
sir,
am I supposed to do?
nope. Did you read the paperwork?
I read the original paperwork, the paper that was supposed to be served. That's all I've read.
Okay, so did you read on the complaint that says that you have 28 days or 21 days to file a written answer?
No, I did not.
Okay, well, sir, you need to read the paperwork that you're receiving.
It was dated for like December 31st.
Well, correct, but then it would go by the new date that you received the service because you didn't receive it previously. So when did you receive it, sir?
Earlier in February.
Okay, so on the summons, it shows Okay, you have 21 days after receiving the summons and a copy of the complaint to file a written answer with the court and serve a copy on the other party or take other lawful action with the court. 20 days if you were served by mail or you were served outside of Michigan. If you do not answer or take other action within the time allowed, judgment may be entered against you for the relief demanded in the complaint. When did you receive it, sir?
I would say around the 13th.
Okay, great. You need to file your written response, sir.
Okay.
And it would be very, very beneficial to read the entirety of the document that you receive.
Yes, ma'am. I did receive an email that when I opened it, it took me to a different link. And I didn't open it because my browser wouldn't allow it. I can show you if you'd like. I don't know what it's for. It said US courts, and I went to open it and it sent me to an outside link.
Does that sound familiar, counsel?
You sent in an encryption email. I don't necessarily know if when it opened up, did it ask you to put in a password? No, it did not ask for a password. What it did do though is it sent me to another link which said home health care or something. I think that's the only other one I got besides the email with the original screenshot of the paperwork.
Okay.
The original court paper.
Okay, so counsel, your law firm allows recording, but you don't allow for an individual calling in to record the,
I have actual audio of it.
hold on, sir.
Then I don't know how the collectors or what their requirements are in that aspect. And then that's the first I've heard, so I don't know.
Okay, well, if you can please chat with your client. But in any event, sir, you should be communicating with the attorney, not with the plaintiff, because
No, man, that's when I call I'm sorry, I don't know the actual name, Steiger, whatever it is. When I call the number that they gave me, they don't allow me to record. They will not.
you're calling the attorney's office.
Correct, I am. The number that they gave me, when I call them, they verify my social, my date of birth, name, all that. And then they tell me that I'm not allowed to record and that they have to hang up the call.
Okay, well, when you're calling an attorney's office, sir, recording, then you have a whole nother level of issues as to why you are not able to record.
Okay.
Because you have a lot of confidentiality issues with attorneys and whatnot. So
It's a call center when you call. It's a person that's verifying who you are. And I don't know exactly how it works. All I know is when I call, it's not an attorney I'm speaking to. It's like the same person. It's like a call center.
okay, but if then they're supposed to be transferring you to the attorney?
They don't tell me anything.
No, are you calling for them to transfer you to an attorney?
They don't tell me that.
No, what is the purpose? When you call, sir,
Yes,
the call
yes, when
center,
I was calling.
but please let me finish the question.
Sorry.
We can only record one at a time.
Yes.
When you're calling into the call center, what is your purpose for calling into the call center?
I was trying to come up with a resolution.
Right, to talk to the attorney.
Right.
Okay, so they get all of your information at the call center, they verify who you are, verify you have a case or what have you, and then you tell them that you're recording or you
No.
want to record.
No, ma'am, I have an app on my phone that automatically records. My son put it on there. It automatically records the phone calls.
Okay,
It actually tells you that if this phone call is being recorded.
okay. And so then at that point, they terminate the phone call and they don't transfer you anywhere, correct?
Correct.
Okay, because they can't transfer you to an attorney that's when the call's being recorded.
And when I did,
Do all of your calls get recorded?
as of right now, yes. Me and my wife are estranged right now, so I just have it set so it records everything.
Well, you may want to call from a different phone then to communicate with the attorney's office or communicate via email. But, sir, you're gonna have to file that answer if you want this matter to continue. All right. Anything else, counsel?
Not related.
All right. Sir, if you don't get that answer filed, I mean, I'll give you, let's see, so you think that you were served on the 13th.
I believe so.
Okay.
That's when I got the email.
So then that is 1, 2, 3. So 21 days is Friday.
Okay.
I will extend your time to answer 1 week to the 13th.
Now, if we come up with a resolution, does that counter, or I still have to file? I don't know how this works.
I know that. So, sir, I can't give you legal advice.
Okay.
But if there's a resolution entered before your time passes for filing your answer, then potentially you wouldn't have to file an answer.
Your Honor, if we help, if he's looking to resolve, if we want to give him 21 days from today, that gives us a little more time. We can
Okay.
help that.
All right. All right, so we're all on the same page. 21 days from today is March 24th. Okay. Okay. Anything else? All right. All that typing wasn't just for that. I was just indicating that the process server was present and I didn't find that she was intentionally deceiving the court. She was not asked to look for any identification, as that is not what she was trained to do. And I will say that I've not heard of that process serving, or that that's how individuals are being trained and through TikTok videos, but okay. Interesting. Learn something new every day. Okay. Thank you. Have a good day.
Thank you.
All right, let's go off the.
Okay, before we move to the next court, we have managed to stumble into 31 flavors of ridiculousness here. First off, he's saying that whoever he was calling, the call center or whatever, wouldn't allow him to record. That's illegal. Michigan is a one-party consent state. I have confirmed that. I seem to recall it from when I lived there, but it's been years since I've lived in Michigan. But it's still a one-party state. If you are a participant in any conversation, private or otherwise, you are allowed to record it. You are not allowed to record as a third party or have a third party record on your behalf. So if you're involved, which he was allowed to record that conversation. So whatever they're telling him, lies. Let me try to share my screen here a second. Forgive me, new software. Are you going to work? Yes, cool, it worked. All right, so this is abclegal.com, the company that she worked for. Service made simple, trademarked. Right up here, be a process server. Serve with ABC Legal. Earn on your own terms, get paid daily. The easiest way to start serving. More than a gig job, how it works. Sign up requirements. You must be 18 years of age. You must have a valid ID and reliable transportation with auto insurance. You have to have a printer. You've got to have a bank account so they can pay you daily. Then simply find jobs, just like you're Ubering or something like that. ABC mobile app connects you to service opportunities in your area. Accept jobs when it works for you. Whether you want to build a full-time route or pick up extra work on the side. Best of all, you get paid next business day. Serve documents, whether it's a court summons, subpoena, or notice, you're the one making sure people get the information they need. How nice. Every document you deliver helps move justice forward. Just print, serve, and make an impact. Yeah, because everybody wants that impact on their day. We'll provide you with a document to sign listing out the details of all your attempts. Get paid daily. Serve, sign, and get paid. And then there's testimonials. But here's where it gets interesting. State requirements. And they list out requirements state by state. Arizona, for example, where the bunker is located, process servers are required to register as a certified private process server with the Superior Court of Arizona. But we scroll down, and what's missing? Michigan. There are no specific instructions for Michigan. So basically, anybody who wants to download the app and have proof of ID and insurance and transportation apparently just gets to serve. Now, I don't know about you guys, but I have huge heaping piles of problems with that. We're talking about documents that can affect a person's life, not only documents that might affect like withholdings from their paycheck, garnishments of bank accounts, stuff like that, but charging documents, divorce papers, heaven only knows what. And we're trusting it to the same kind of tech and the same kind of mentality as DoorDash. I'm not knocking on DoorDash, but come on, this is on a different level. This is insane. So yeah, this just might be a sidebar topic at some point or something. Anyways, thought I'd share. That's what's going on. I had no idea until we stumbled into this mess. Are you excited about it? I'm not. All right. End rant. Judge West.
Good morning, sir. Are you Justin Joseph?
Good morning.
And this is 20-35818. And Mr. Joseph is on probation. It looks like it's, hold on a second, let me get that pulled up. A straight probation from July 11th of 2022 for the offense of evading arrest or detention with the use of a vehicle. Looks like that was a 10-year sentence that was probated for 10 years. There's been a motion to revoke filed in that case. So the allegation, count one, it looks like, is that there was Mr. Joseph had failed to submit to either drug or alcohol testing November 4th, December, several days. And then there's an allegation that Mr. Joseph failed to submit a valid urine specimen and that he attempted to provide the toilet water from the urinal instead of himself, and then just a little bit behind in fees. And Mr. Lewis has filed a motion asking that I set a bond. In Mr. Joseph's case, at this time, there is no bond set. Is that correct?
Yes, ma'am.
There's also actually, he's on probation for 2 cases. Additionally, there is F-23-5476, which is set on a different day. I don't know if the.
Right, sure. Did you file in that case as well? Or did we?
I initially did, but I
Okay.
think we wondered if it was dismissed or something like that.
Hold on.
And I know he's seeking a bond in both cases, Judge. I'm okay with proceeding on both today.
Well, I need to see what it is.
I'd seen that it was set like on the 31st of March.
Mhm. Okay.
Let me get the bit. And Judge, it's a second degree, also straight probation, same term, same allegations. I don't,
Okay.
I know y'all are grabbing Fowler for.
Well, yeah,
I
we
don't
gotta
have
make sure
a problem.
because for some reason, we've got Miss Holmes on the other one and the other date. So let me get it where I can look at it. Yeah, give me just a second. Now I'm stuck here on this. And so obviously we'll put Mr. Lewis on both cases. Mr. Lewis probably didn't know about it because he didn't have any of that information if Miss Holmes was appointed, so you weren't given that information.
No, and I want to say I did file.
Did you?
Which is the one that has pretty on it now,
Which one, what?
that Ms. Holmes is on now.
35476.
Have somebody else in the case you filed for a bond and the case is dismissed.
I know it was, yeah, I remember that. But I thought it was him.
What do I have to put? F and then the dash, all of it?
Dash just, yeah.
Yeah.
No, it's okay, I forget.
818 was.
818 is the one that I have here today with you, that you filed.
And I filed in
818.
no, 35394.
We don't even have that one.
That one was dismissed. That's not.
So there's a third.
that's
one.
Third case.
There we
That's what it
go.
was.
Okay,
Okay.
so we obviously will switch for you. Do you need a second to look at? Let me hold it, Mr. Nichols, if you'll just kind of show Mr.
I'm good.
Lewis.
I mean, everything's the same, Your Honor, the allegations, the motion.
Yeah, y'all take just a
It's
minute
straight
and then I'll
probation.
also get it pulled up, so I'll have everything to look at, and then we'll do it in just a minute. Just have a seat in the jury
Good.
or wherever they want you.
Good enough.
No, it's good. Who knows how that?
Well,
I'm gonna print this second motion just so I have it in front of me.
Okie dokie. Parole board, contestant number 3.
Okay, what is your DLC number?
462614.
Okay, do you have a waiver in front of you that you signed that about this particular hearing that we're in today? Yes, sir. I think that's probably it. They talk about an attorney and that you're not eligible for an appointed attorney.
Yes, sir.
Okay, and you're ready to proceed this morning, correct?
Yes, sir.
Okay, thank you. All right, well, your case has been assigned to me, and when you get out of jail, when you get out of prison, you sign a sheet that says you'll abide by these number of conditions. And the conditions, if you violate those, then we have to have a hearing to find out if you truly violate it or not. And so you're accused of violating conditions 4 and condition 10. You've had a preliminary hearing and they determined there was probable cause to believe that you did. We're here to make that final determination. Let's talk about number 4 first. Is it true that you pled guilty on 12/11 of 2025? You pled guilty to domestic abuse, first offense, and for violating a protective order. Is that correct?
Yes, sir.
Okay, and you got 6 months in jail. They were to run concurrent, and let's see. I think that's about all there is to it. You want to tell us about anything else about that other than you pled guilty to having violated that?
Well, I pleaded guilty because I was because of my background. I didn't feel safe going to actually trial with the case, even though, but you know what I'm saying, I feel like it still was possibility that the jury might find me guilty because of the way the DA might proceed it. But other than that, you know what I'm saying? The reason why I'm not denying the fact that by me, my plea of guilt to a misdemeanor, you know what I'm saying, is still a violent charge. So I understand there's a possibility that the board still can find me in violations of my conditions. But at the same time, the reason why I wanted to come speak with the board because of my situation upon my release. The victim in my case was where I was in a relationship, though I was located, that's who I was living with. And since I don't plan on being with the victim upon my release, I was asking the board if possible that I could be asked for some help from them because of the fact that when I get out, by me not being with the victim, I'm not going to basically have a resident. I'm from Shreveport. I come here from Shreveport looking for a better chance to get off around what I'm basically trying to get off around what I know, and it's always kept me in trouble. I mean, everything was easy access to me. So therefore, I was saying by me coming here, you know what I'm saying, that was my process of trying to better myself. And like I said, upon my release, if I was to release today, you know what I'm saying, I won't have no basically nowhere I'll be basically homeless upon my. So I was asking the parole board, even since I'm gonna be in violation of my parole, or if they're gonna see me in violation of my parole, okay, which is I have like a year and probably a month left on parole. Upon the calculations, DOC would probably be like a remainder of 5 months at the most. So I was asking parole if possible. I mean, if the board, if possible, they could place me in a road release program for at least 6 months, or the remaining of my sentence on my parole. Therefore, upon my release, I at least had the opportunity, you know what I'm saying, to obtain a job that I might possibly be working at, you know what I'm saying, the way I already, forced me releasing, I always had problems with trying to get back in, get comfortable back with society, and go force going like to companies or whatnot, putting the application, even though most of it's online now. It's like I have a hard time like coping with society, trying to get myself back comfortable with society. So I know sorry.
Okay, let's slow down a minute. Do I understand you right in saying that you are willing to voluntarily revoke yourself?
I mean, it's possible. If I say I feel like the board is gonna do it anyway, but at the same time, like I said, I don't have no reason to go on to. But 5 months, I feel if they can give me the 5 months in the road release program, that way I can try to culminate something. So when I get out, I won't have to just walk back out there with nothing. Yes, sir. I'll be willing.
Well, you kind of putting us in a bind here.
Sorry.
Okay.
Yes, sir.
Let me ask you something. Did you call this woman 117 times?
Yes, sir. Probably more, but when I first got here, we was in the process of her trying to bum me out because she didn't feel that she wanted, because she basically stated to the officer herself that she wasn't pressing charges on me. But no, by being whatever for the reason, they said the state pick it up, so they press charges on themselves and whatnot. But no, I'm saying we was in the process when I first got here. I wasn't familiar with the fact that I was on a protective violation, so I was contacting them from the start. And once I did find out about it, we was in the process of trying to bond out. And it was in my mind then. I'm like, if she gonna be getting me out, you know what I'm saying, I didn't mind pretty much violent, even though I knew it was no.
Okay.
Yes, sir.
You got a lot of words in your body, don't you?
Yes, sir. Yes, sir.
Okay. Let's I think we got that straight on the domestic violence thing. You pled guilty to it. You pled guilty to violation of protection order. You called her that many times. And the condition number 10 says that you owe $1,071. Is that true or not?
Yes, sir. I mean, it was like 300 something when I first got arrested, but I guess they added my incarceration time.
Yeah. Okay, and so what you're wanting to do is revoke yourself, provided you can go to work release.
Yes, sir.
Okay. And that I think we passed. I think that horse is out of the barn, I believe. I think it's gonna be our decision to make. Does the board have any questions there?
I have no questions. You're gonna get the office to do it, sign. Or doesn't matter.
I'm sorry,
What was your name?
Deputy Exnicious.
Okay, thank you.
You're welcome.
Okay, Ms. Jerry, you got any questions? Okay. Mr. McKay, it's up to me to vote now because we don't have any more questions. And I think that's great that you want to go to work release, but you're gonna be getting out in a little over a year anyway. And being a sixth class offender, I don't know that to reward you with a work release would be, the most we can do is in lieu of revocation, put you in 6 month work release. And I think because of the violations that you have and because how many times have you been on supervision before?
I guess I got like probably 6 convictions, and every time I come on, I'm still basically on the supervision.
You get revoked every time you get on?
Yes, sir.
Okay. All right. My vote is to revoke your parole today and make you spend some time and be accountable for what you did. That's my vote.
My vote is to revoke based on violence against another person during your period of supervision.
My vote is to revoke, for rule number 4.
Okay, as of today at 9:59, your parole has been revoked because of violation of conditions 4 and 10. Okay, thank you, sir.
Yes, sir.
All right, we'll continue running in the South. Let's go back to Judge West.
8, and then there's an additional probation in clause number 2035476. Mr. Joseph is on probation in that case for possession of a controlled substance, a second-degree felony. That was a 10-year term that was probated for 10 years and also has those same allegations. And so what I'll do, just for purposes of this hearing, there's no bonds on either of the cases, correct?
Sure.
And I'll let you kind of file after court the representation and that request for a bond, but let's go ahead and hear it all at this time.
Okay.
And so, Mr. Lewis, do you have a witness on the bond?
Mr. Joseph.
Mr. Joseph, best you can, raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, go.
Mr. Joseph, you state your full name for the record.
Justin Joseph.
Okay, and Mr. Joseph, you do understand we're here to address your bond issues in regards to these cases?
Yes, sir.
Okay, now, as far as your working situation, do you currently have a job?
I was going back and forth to the Port of Bowman, but before all this had happened, I had filled out an application for AMPO.
Speak up, please.
I said I was working back and forth at the Port of Bowman, but before all this had happened, I had just filled out an application for AMPO off of West Calder doing vacuuming and hydroblasting. Now I'm supposed to start that, but turn myself in to take care of all this.
And as far as any additional responsibilities, especially in regards to your family, what kind of responsibilities are those?
Kids, and I'll take care of my uncle that just recently fell from out of the ceiling or out of the attic or whatever. He broke his hip bone. So I'll be having to help him take care of him, take him in and out the bathtub. You have to take him to the restroom because he can't walk and he don't have a walk or anything like that.
So you basically use his primary caregiver when you're not working?
Yes, sir.
Okay. Now, as far as expenses, do you have any property or any money saved to put up that you could put toward the bond?
Yes.
Okay. Approximately how much of a bond would you be able to make?
Probably like 10,000 a piece, or no more than 20,000 a piece, probably.
Okay. And as far as any conditions of a bond, a lot of these allegations, of course, deal with drug use. Do you have any concerns or objections to wearing a drug patch or applying with any pretrial conditions judge would have for you?
So I can wear a drug patch, ankle monitor, or whatever you need me to do.
Listen, I pass the witness, Judge.
I have no questions for this witness, Your Honor.
All right, any other witnesses?
No, Judge.
Any witnesses, Mr. Nichols?
I have Ms. Cole here, Your Honor. I'd like to ask her briefly. a couple
Yes, of course.
questions.
Good morning, ma'am. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Yes. Thank you. Go ahead.
Ms. Cole, are you the officer that's been supervising Mr. Joseph?
Yes, sir.
And how long have you done that for?
Since he got out of safety placement and started outpatient, so that would have started in November.
When was he ordered to go to safety?
He was ordered to go to safety January 9th, 2025.
And so after he completed that, he was, was he successful at safety?
He was successful in the unit placement and the residential aftercare, but not the safety outpatient aftercare.
When did he complete that residential aftercare?
The residential aftercare was completed October 24th, 2025.
And then after that, he transitions to the outpatient aftercare.
Yes,
Is that
sir.
correct? When did he transition up there?
He started that November 18th, 2025, when he returned to Jefferson County.
And is that when the violations began?
Yes, sir.
And what were the nature of those violations?
He has not submitted for one UA since being out of safety. He's came to the office and he has failed to submit every single time that he has showed up.
What can you tell the court what happens when he fails to submit? He's in the office, he's told he needs to do your analysis. What happens?
The last time that he failed to submit, he said that his sister had emergency surgery and we were in the UA lab. And I said, if you walk out that door, this is a failure to submit. And we went back and forth for about 5 minutes and eventually he got it, walked out and left.
Took longer arguing about it than it would have just to do it.
Absolutely.
What happened on January 14th of 2026?
He actually I was out sick, but my supervisor called me at home. He had an admin hearing. And during that, the other safety officer, Officer Robert Menard, tested him. And as he was testing him, Mr. Menard observed him scooping the water out the urinal and handing it to him for a UA. It was cold and it was clear and there was no way it was his urine.
I filed the complaint.
Don't talk unless somebody's asking. Don't talk unless someone asks you to talk.
Are you familiar with the circumstances of his apprehension?
He was supposed to report to my office, but he failed to report. And all I saw was that he got arrested. But in the midst of that, I was getting phone calls saying that he was in Houston at the hospital with his child. And the mother of the child was calling, stating that he was under the influence and scaring her. I got 2 different calls and another officer got a call as well.
Was he arrested in Houston?
No, sir. He was arrested in Jefferson County.
Do you recall that he was causing an outburst or some sort of disturbance in Houston?
Yes, sir.
Okay, I'll pass witness.
Any questions of this witness?
Just briefly. To the safety aftercare, what does that entail?
Which one? There's 2 different ones.
Which one was Mr. Joseph assigned to?
He was assigned to, but there's 3 phases of safety.
Okay.
The unit placement, which is in the prison, the residential aftercare, which is at the halfway house, and then the outpatient aftercare is a 9-month program where he has to attend 2 groups a week, 2 individual counseling sessions with a counselor per month, submit to random UAs, attend NAAA meetings twice a week, and obtain a sponsor within 90 days.
Okay. So basically the urinalysis is all part of that 3rd section or what you talked about for that.
Yes, sir. All of that is part of that. And that's the main component of it, because if he's in the SAFE program, that means he has a substance abuse issue. And if you're not willing to submit to that, to probation, that is a presumptive positive.
Okay. I have nothing else.
No other witnesses, Your Honor.
Okay. And so, Mr. Nichols, what's the state's position?
Judge, he's got 3 prior felony convictions. He's on straight probation on these 2 cases. At the time he was placed on probation, a felon in possession of a firearm case and a possession of phencyclidine PCP case were also dismissed. He was put on high medium caseload. He's failed to follow through with what he's been ordered to do with SAFE. He was ordered a little over a year ago to do the SAFE program and has chosen not to comply with the requirements of it afterwards, and he's tried to falsify the testing. Judge, while he may be entitled to a bond, I would ask that the court make it sufficiently high to keep him here in Jefferson.
No, they're both adjudicated, so it's not
Then I'm asking for no bond, Judge, because frankly, I don't think that he's done anything to show the court that he's going to follow the court's rules while out on bond.
All right, Mr. Lewis, argument.
Judge, understandably, yes, he is not entitled to a bond. We are asking for one, given the issue of him trying to maintain employment and also caring for his uncle while we're out getting this, trying to resolve this issue. I believe any concerns of the court can be cured by the drug patch or some sort of pretrial condition that can monitor any drug use or anything while he is out on bond. I believe a bond of $15,000 for each case will be sufficient of that. He's definitely, once the violation came up and everything, I can only speak to, my involvement as far as him doing trying to do what he needs to do to get things, taken care of. Some of these allegations are my first time hearing about him, but and I'll address them with Mr. Joseph. But as far as his bond, I do believe a bond of $15,000 will be sufficient to maintain his return to court, and also a bond condition of a drug patch or a scrambled wax or something of that matter could definitely keep the court in the loop, if you will, as far as if he does relapse or is any other drug use.
Well, here's the problem, Mr. Joseph. There's nothing more strict really than going through that safety program and the aftercare. And that's, like Mr. Lewis said, for me to keep an eye on you is for probation and those programs to keep an eye on you. And what I'm seeing and what gives me concern is that back last year, I'm looking at the administrative hearing that led you going to SafeP. And at that point, you had tested positive for PCP numerous times, and you had also failed to submit numerous times to testing. And then you went to SafeP, and then it just looks like it's the same problem that we don't know. But I would tend to think it would be a fairly good assumption that you were using PCP again. And that's why you didn't want to submit on the numerous dates that you have here. It makes no sense for me to say, okay, well, we sent you to SafeP because you had a problem with PCP. You got out and then you did aftercare and you couldn't get through it because you were trying to either falsify or not show up. So it doesn't make any sense to me that it would be safe to put you back out in the community at this point, because you're not going to just remain on probation, either not at all or without some further inpatient treatment, which we've already done. So I'm not sure where we'll get on the motions, but as far as the bonds go, I'm going to deny those motions in each case for a bond and leave these both at a no bond, because I feel like that is in the best interest of our community, to keep everything safe and to keep you from using something as serious as PCP. All right. What?
Say I don't use.
Well, then why didn't you take the test?
The only time I gave it to my attorney, Mr. Lewis, when I had, I'm on colors over there. So whenever my color had came up, I was at the emergency room. I gave him my doctor's excuse, and I also brought it to Ms. Cole, and that was cool.
There's 1, 2, 3, 4, 5 allegations that you didn't submit. That you didn't submit, and then there's the one where you did, and the allegation is that you attempted to get it out of the toilet.
Yeah, that's what I had. Because when you,
I'm denying the bond. You can go back with the bailiff.
Well, okie dokie, just cut him right off. But that's her style. Sometimes she just hears enough. She's not going to mess around anymore. So, a couple things real quick. First off, sidebar tonight, 8 p.m. Eastern, 5 Pacific, right here on this channel. Be sure to check it out. It's not just me. It involves people who are with us in the chat every single day as we talk out legal topics and whatnot and so forth. And sometimes we even venture into things like cooking. So, you never know where it's going to go, but it's a lot of fun. On your way out today, do me a favor. In the pinned chat is a link to a survey. Please give me 2 minutes of your time and take that survey if you have not done so already. Basically, it's just me checking up on your thoughts of the channel. As we continue to grow, I kind of want to get a feel for where the audience is at. It is anonymous, so I'm not collecting any of your data. And just be honest with me. If you could do that for me, I'd very much appreciate that. And also, this Thursday is the 1-year anniversary of this live show. So if you could all join me on Thursday, that would be great. I don't know that I necessarily have anything super special planned or anything like that. I'd just like to have as many of you here as I can. as we celebrate 1 full year of me getting up early every morning to spend time with you guys. It's very cool. I like it. All right, let's finish our day back at the board. Let's go try them one more time.
The Committee on Parole, and we're going to be hearing the case of Mr. Toby James. And my name's Steve Prater. To my left is Mr. Tillis. To my right is Ms. Ledoux. And we're going to be talking to you about your revocation hearing. Mr. Toby James, is that you?
Sorry, pause real quick because I did forget one thing. Helen, thank you for becoming a channel member. Welcome to the family. It's good to have you here. All right. As we were.
Sir. And what is your DOC number?
424991.
Okay, do you have a form in front of you that you signed?
Sir.
Okay, it says, and you signed that and you understood that form, attorney and appointed attorney and all that sort of thing, and that you weren't eligible, but you could hire an attorney if you wanted. You understood that?
Yes,
okay,
sir.
this has been assigned to Mr. Tillis, but before we go there, is there anybody from Vernon Parish Jail that is in? Would you introduce yourself, please?
Yes, sir. I'm Captain Williams.
Okay, thank you for hosting us today. Mr. Tillis, I think I'll turn it over to you. And
okay. Good morning, Mr. James. How are you doing?
I'm doing good.
We have you in violation of rule number 4. You committed the offense of aggravated assault and was arrested by the Lee's Police Department on 11/5/25. These charges were dismissed by the 30th Judicial District Court, District Attorney's Office on 12/18/25. How do you plead to that charge?
Not guilty.
With a statement?
Yes, sir. It was he put a false statement on it. He was talking to my stepdaughter, and I just was talking to him, and he said I pulled a knife on him, and I never did. And I couldn't see my parole officer in him, and that's where the city come up there. But I never pulled a knife on him or nothing like that. I mean,
it was said you had 2 knives. Did you have 2 knives with you?
No, sir.
You didn't have any knives with you?
No, sir. I just come in from work to go see my probation officer the same day. I had no knife on me or nothing.
Okay.
Then there's cameras all around my apartments. And so when I went to court, I ran the cameras back and seen I had no weapons or nothing on me. And so the judge dismissed everything off of them.
Did you, what was he angry with you about?
Because he was trying to talk to my 15-year-old stepdaughter. And I come in from work and told him that she was too young. And we were just sitting there talking, and he got mad. He was trying to put me out. He knew I was on parole. So he called the law on me, he can put me in jail. So that's what he did, just to get me out of the way. But I never pulled no knife on him or nothing like that. But, you know, this guy went to court and they'll see it on camera and stuff. I never pulled a knife and dismissed the case. And then I went to arraign it, and that was it, sir. I never went to trial or nothing like that.
You're a 4th offender?
Yeah, yes, sir.
Okay. I have no more questions.
Mr. James, how was your conduct while you were on supervision?
It was good, ma'am. I reported every month. I passed all my drug tests. I caught up all my payments, and I was working moving trailers.
I didn't note any violations while you were on supervision. So you must not have, this is because it's a crime against a person that they held you and didn't do a technical violation.
That's right.
You've been detained since December 25.
Yes, ma'am. I got arrested November 3rd for the charge, but I bonded out and went home for a whole month. Then they come back and re-arrested me in December. So I bonded out on the charge.
They re-arrested you because you were on parole, and it was a crime against a person.
Yes, ma'am, but I gotta, oh, that my probation officer, the same day that he said I pulled it out, and they knew I was, on probation, they the one walked me over here to the sheriff's office and never put a hold on it, so they let me find out in December. They come back, so we made a mistake, we were supposed to put a hold on. So I was out, working.
Okay, so, have you been clean? No substance abuse while you've been out?
No, ma'am, I've been clean. I've had all my drug tests, alcohol tests, and everything. I've been working and trying to get my life back straight. You working for me too. And I work for Mr. Williams there at Vernon Ferry Jail. I'm a trustee there.
So what do you do when you were out? What kind of, you were moving trailers, right?
Yes, ma'am, mobile homes and stuff.
Uh-huh.
And I was filing for my disability because I hurt my knee. So, but I was working on the side.
Well, any injury like that can lead to drug abuse. You gotta be careful.
Yes, ma'am.
Any question?
You said you didn't have 2 pocket knives?
No, sir. I went in my probation officer, they searched me, put everything out of my pocket, and I never had no knife.
But did the probation officer go out in your car and or your truck and get 2 knives out of the glove box?
I don't know, sir. I mean, I ain't.
Says in the report he got the 2 pocket knives out of your glove box and put them in the
I ain't got a report on none of that. And it's none of that.
You would know if it happened, wouldn't you?
Yes, sir.
Did it happen?
They went and searched my vehicle, somebody found out because the seat was there.
Did you know they got 2 knives out of your vehicle?
No, sir.
Okay, well, they did.
Yeah, that's for the 2 knives.
See, I'm kind of bothered by the fact that I had to drag that out of you.
I ain't got no knife. I don't know if they pulled a knife out, but the city was there. The city arrested me, and all they charged me was that. There's none of my paperwork saying I had a knife. I mean, all my motion and coverage they gave me, it showed that I ain't got no knives. I mean, they didn't tell me none of that.
Well, they shouldn't have to tell you. Did you have 2 knives in your glove box?
No, sir.
You didn't?
No, sir, I didn't have no knives, no weapons or nothing.
There's a search of the vehicle, you had 2 pocket knives found in the glove box of the vehicle. Both pocket knives were confiscated, placed in an evidence bag, and this is parole officer that's saying that.
Oh, no, sir, I ain't seen no knives. That's honest to God truth. It's nowhere in my motion of or nothing. If they had found a knife in there, I wouldn't have lied about it. I'd go to yes, sir. But it's no picture or nothing of a knife they found. And it ain't none of my paperwork that they found a knife. So I mean, I don't know. I ain't calling them a liar or nothing like that, but I ain't got the paperwork saying there was a knife.
I don't have the other one.
You ready to move?
Okay.
Mr. James, my vote today is going to be to revoke for rule number 4. Yeah.
Okay.
My vote is in lieu of revocation to send you to a transitional work program for a period of 6 months. I don't think that you've been totally honest, but about the knives, but I think that would be in the best interest. So that's my vote.
Okay, thank you. In my vote, I concur with Mr. Tillis. I think because the violations of 4 and 10, that your parole should be revoked today. And as of 10:12 this morning, your parole is revoked. Thank you, sir.
And there we go, friends. That brings it to a close for today. Well, not for the whole day, I guess. We got Sidebar tonight, 8 p.m. Eastern, 5 Pacific, right here on this channel. So please do join us for that. Thank you to everybody for your gifted memberships, your super chats, your just participation in the chat, all those things. Please do consider doing me a favor on the way out the door if you haven't already, and go to the pinned chat and visit that survey. Taking no more than 2 minutes of your time, but it gives me feedback on where the audience is and will kind of help me as we continue to grow. So I'd appreciate that. Yeah, we'll see you tonight on Sidebar. Otherwise, we'll see you back here tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour early for channel members. Ellie, do you want to come say goodbye to everybody? Come here. Come here. Well, don't show me your rear end. That's not a good way to say goodbye. Come here. All right. Look at them. Tell them bye. All right. We'll see all you guys tomorrow. Take care. God bless.